My name's Don Jacobson. I'm a senior court judge, meaning that I've retired, but I come back and help out very regularly down here. What we're here for is first appearance. I'm going to go over some information with you, but first of all, I need all of you to raise your right hands.
Todos levanten la mano derecha.
Each and every one of you swear to tell the truth, the whole truth, and nothing but the truth. So please say I will.
Todos ustedes juran que dirán la verdad, toda la verdad y nada más que la verdad. Si es así, digan sí en voz alta, por favor. Yes.
And I see everybody looking at that has raised their hands and affirmed. Okay. Let me just explain what we're doing here. And we have some Spanish interpreters. Can you read this? I think you have this, Mr. Hernandez, do you not, that you can read over it after I'm done?
That is correct, Your Honor.
Okay. I want to give you some information about first appearance. This is a first appearance hearing. A first appearance hearing really has four purposes. The first is I'm going to be advising you of the charges that you face. Secondly, I will ask if you have an attorney or want an attorney. If you've hired counsel, they may be present here, and we do have some private attorneys here that will be handling some cases. If your attorney's not present and you want to talk to them first before moving forward, we can postpone this. If you postpone the hearing, you'd be able to contact your attorney to let them know they'll need to be here. If you wish to move forward without your attorney present, you can do that. If you do not have an attorney and wish to have one, I will ask whether or not you would like to have a attorney from the Public Defender's Office, at least tentatively appointed or provisionally appointed for you, and so you can fill out the paperwork in order to qualify for the services of a court-appointed attorney. A court-appointed attorney, there's a $40, $50 now. $50 indigency application fee that you'd have to pay, and a possibility of some small amount at the conclusion of the case if you're ever found guilty or enter a plea. So the very first question I'll be asking you is whether or not you have an attorney or want to have an attorney appointed. I just recommend that it's always good, especially if you're in custody, to have a lawyer in your corner working on your behalf. But I can appoint provisionally somebody from the Public Defender's Office to represent you pending the filing of your application. The third thing I'll do is to determine if there's probable cause for you to be in custody. I have spent the last 2 or 3 hours going over the voluminous amount of paperwork here that I have for each and every one of you concerning the charges that are brought against you, to kind of familiarize myself with the cases. So I'll be addressing whether or not there is probable cause for you to be in custody and under arrest. Finally, what I'm going to be doing is determining whether or not you're entitled to some type of bail or bond or pretrial release of some sort. If you are placed on a pretrial release, I'll go over some matters, but the primary thing with pretrial release is that you'll be supervised and that you will be monitored, and I will go over what the conditions are. There are some general conditions that I'll go over, and then some very specific ones that are case specific for you. Please remember that if the court places you on pretrial release, regardless of whether it's straight pretrial release or as a condition of your bail or bond, the conditions that I announce here in court go into effect immediately, even though you're in custody. As an example there, if somebody has a pretrial release condition of no contact with an alleged victim, that no contact provision that I announce would start immediately. So you would not be able to use the phone to contact somebody that you've been ordered not to have contact with. Let me just further explain. This is a recorded session. This is not a trial. This is a very preliminary matter. And what I will be doing is, going over some matters with you. You're not obligated to say anything about what's going on. In fact, I encourage you not to say anything about whatever case it is that you're in custody for. Everything that you say is recorded and could be, and most likely would be, used against you later. So again, it's a matter of right to remain silent about anything concerning the charges you're facing. There is an assistant state attorney present here in the courtroom. He will be taking notes, and if you start saying something that could further incriminate you or be used by them, I'm guaranteed that he'll be writing it down and providing that to whatever attorney's assigned to handle the case on behalf of the state attorney. As we go through this, I try to go through it as expeditiously as I can. But it's a matter that it does take some time. With that having been said, I think we might have, do we have any, let me have Ms. Hernandez. Ms. Hernandez, would you kind of explain what I just did in Spanish for the Spanish speakers?
Yes, Your Honor. Thank you. Buenas tardes. Esta es su audiencia de primera comparecencia. La audiencia de primera comparecencia tiene solamente 4 propósitos. Primero, les informaré acerca del cargo o los cargos que se han presentado en su contra. En segundo lugar, les preguntaré si ya les está representando un abogado. Si ya han contratado un abogado y éste se encuentra presente, entonces será el abogado quien hable en representación suya. Si su abogado no se encuentra presente, tendrán la oportunidad de proceder con su audiencia el día de hoy o posponerla hasta mañana. Si decide posponerla, será responsabilidad suya el contactar a su abogado para hacerle saber que mañana tendrá una audiencia. Nadie más hará esto por usted. Si usted desea proceder sin que su abogado esté presente, puede hacerlo. Si usted no tiene abogado, le preguntaré si puede pagar uno. Si usted sí puede, entonces tomaremos nota de esto y procederemos. Si no puede y califica, el juez asignaría provisionalmente a la oficina de abogados de oficio para que le represente, en espera de que usted llene una solicitud para estos servicios. Usted tiene derecho a que un abogado esté presente antes y durante cualquier interrogatorio. En tercer lugar, si hay alguna objeción en cuanto a motivo fundado, esta se abordará inmediatamente. Finalmente, voy a estar revisando sus fianzas y otras condiciones de liberación condicional para determinar si es necesaria cualquier modificación. Debe saber que si el juez lo pone hoy bajo libertad condicional, independientemente de si es directamente o como condición de su fianza, las condiciones que se anuncien hoy en esta audiencia entrarán en efecto inmediatamente, aunque usted se encuentre encarcelado. Por ejemplo, si se le ordena no tener contacto ni comunicación con determinada persona y usted llama a esta persona desde la cárcel antes de salir en libertad, usted estaría incumpliendo su libertad condicional. Durante todo este proceso, usted tiene el derecho constitucional de permanecer callado. Si decide no permanecer callado, todo lo que diga puede ser usado en su contra. Todo lo que se diga donde yo me encuentro y así como también donde se encuentra usted está siendo grabado. Hay un abogado de la Fiscalía presente escuchando todo lo que aquí se dice, así que no digan nada en relación al delito mismo ni los hechos de su caso. Por favor, tengan presentes estos derechos durante el transcurso de este procedimiento. Favor de pasar cuando se llame su nombre. Gracias. Thank you, Your Honor.
Thank you.
You're
And
welcome.
do we have any of the inmates that need an interpreter? Do we have any Spanish speakers? Sixth and Central? Okay, and Central is all here. Do you have them so we can get our interpreter out of here? Call them up. They can usually be interpreters.
Camacho.
Camacho,
Yeah.
pase al frente, por favor.
Thank you.
First person is whom?
¿Esta persona es quién? Camacho, Your Honor.
Sí.
C-A-M-A-C-H-O.
We're dealing with, it looks like Alberto Camacho or Villasmil.
Parece que estamos en el caso de Alberto
Sí,
Camacho Villasmil.
Okay, sir, you are here charged with unlawful use of the driver's license, knowingly driving while your license was suspended or revoked.
Señor, usted se encuentra aquí porque se le acusa de hacer uso ilícito de una licencia de manejo y de manejar a sabiendas con licencia suspendida o revocada.
Would you like to have a lawyer appointed?
¿Quisiera usted que se le nombrara un abogado?
no.
No.
No, you're going to hire your own lawyer.
¿Va usted a contratar su propio abogado, señor?
Sí,
Yes.
Okay, these are both M2s.
Ambos son delitos menores del segundo grado, M2.
By way of interest, why isn't a bond set up something like this before today? Any idea?
Immigration status.
Mi pregunta es por qué se fijó la fianza de esta manera. ¿Es algo que se hace ahora? ¿Alguna idea? Es por su estatus migratorio, potencialmente inmigrante.
I'm setting your bail amount at $250 per count.
Voy a fijar la fianza en $250 por cargo.
And you've indicated you're not hiring an attorney at this point. Or you're going to hire your own attorney.
Y usted indicó que usted no quiere que se le nombre un abogado o que va a contratar un abogado privado, ¿cierto?
And I've looked over
Sí.
the probable
Yes.
cause affidavit. There is probable cause. Again, your bail is set at $250 per count.
Ya revisé la causa razonable y sí hay causa razonable y de nuevo la fianza se fija en $250 por cargo.
Versus city/county judge.
Start over. That work? Okay, and who is our next?
Eso es todo, señor.
Ya.
¿Quién es el siguiente?
Hernandez, Bonitez.
Hernández Benítez.
Yes.
Hernandez.
Hernández Benítez.
He's in Central, right?
Sorry. It's Hernandez. Yes, sir.
This is Brian David Hernandez Benitez.
¿Es usted Brian David Hernández Benítez?
sí,
Yes.
And sir, you're here on a no valid driver's license,
Usted está aquí por no tener licencia válida de manejo,
but apparently there is an ICE hold on him.
pero aparentemente hay una orden de arresto por parte de inmigración en su nombre.
And there's also a FTA CAFIAS issued for you indicating a no bond hold with a 5-day hearing to be held. So you'll be taken in front of another judge within 5 days on the no bond.
También hay una
Warrant.
orden de arresto por falta de comparecencia en su caso y se indica que no hay fianza en este caso y va a haber una fianza el 5º día después de su arresto. Va a ver usted a otro juez.
And again,
puedo,
May
Voy. puedo decir unas palabras.
I say some words?
no, do you wish to have a lawyer appointed?
No, señor. ¿Quiere usted que se le nombre un abogado?
No,
No.
Okay, again, what I have is a capias, which is in essence an arrest warrant issued by a judge indicating you're to be held and taken in front of that judge. So that will be done within the next 5 days.
Ok, lo que tengo aquí es en esencia una orden de arresto que fue emitida por parte de un juez indicando que va a haber otra audiencia ante ese juez que será dentro de unos 5 días.
And you've indicated you do not want to have a lawyer.
Y usted me ha indicado que no quiere que se le nombre un abogado, ¿cierto?
Yo voy a pagar uno.
I'm going to hire one.
Fine. Okay, sir, you'll be given an opportunity to do so.
Muy
Who's our
bien,
next
señor.
speaker?
Se le dará
for the panel?
oportunidad de hacer eso. ¿Quién es el siguiente? Eso es todo, señor.
Luna, Roland Luna.
How do you spell that, Madam Bailiff?
Luna.
Luna,
Ujú.
We have
Roland.
Roland Luna present.
Tenemos presente a Roland Luna.
You have a
Sí.
lawyer or you're
Yes.
planning on hiring one?
¿Tiene usted un abogado o planea contratar un abogado?
Planeo contratar a un abogado.
I plan on hiring a lawyer.
Would you like to have a lawyer appointed, sir?
¿Quisiera usted que se le nombre un abogado de oficio?
No.
No.
You hiring one then?
Entonces usted va a contratar uno, ¿cierto?
Sí.
Yes.
Okay. Sir, you're here charged with a domestic violence assault, charged as a second-degree misdemeanor.
Usted está aquí porque se le acusa de agresión, amenazas en violencia intrafamiliar. Estos son cargos de delito menor del segundo grado.
State's recommendation on these it's only second-degree misdemeanor.
¿Cuál es la recomendación de la fiscalía? Esto es solamente un delito menor del segundo grado.
State requests a pretrial release supervision with no contact with the victim, no possession of weapons or firearms, stay 500 feet away from the victim's home, place of employment, school.
And what about the bail amount?
With regard to the bond amount,
La fiscalía solicita que se le mantenga bajo supervisión por parte de servicios de libertad condicional. Se le prohíbe tener cualquier tipo de contacto o comunicación con la víctima. Se le prohíbe poseer armas de fuego, armas blancas o cuchillos o munición. Mantenerse alejado de la víctima por lo menos 500 pies de distancia. Esto es de la víctima misma, su hogar, su lugar de empleo, su escuela. Y que haya en relación a la cantidad de fianza. Oh, perdón.
with
Yes.
regard to the bond amount, Judge, I don't have a specific recommendation. There is a bond schedule for M2.
It's a
En relación a la cantidad de fianza, su señoría, yo no tengo una recomendación específica. Ya hay enlistado la cantidad de fianza para un M2.
Pursuant to the bond schedule, I am setting the bail amount at $250.
De acuerdo al listado de fianzas, voy a fijar la fianza en $250.
As a condition of pretrial release,
Como condiciones de libertad condicional,
there's standard conditions, and these will apply for everybody. No criminal activity,
va a tener que cumplir con las condiciones estándar de libertad condicional,
No
las
use.
cuales se aplican a todos.
no use or possession of illegal drugs,
Se le prohíbe usar o poseer drogas ilegales y no puede cometer actos delictivos.
not leaving the state without the court's permission,
Se le prohíbe salir del estado sin permiso previo de un juez
and no driving without a valid driver's license.
y se le prohíbe manejar sin tener una licencia válida de manejo.
More importantly for you,
Y más importante que todo para usted,
condition 16,
la condición 16,
no possession or of any type of firearm, gun, weapon, ammunition, or knife.
se prohíbe que usted posea cualquier tipo de arma de fuego, armas blancas, cuchillos o munición.
You're prohibited from having any contact with this victim until further order of the court.
Se le prohíbe tener cualquier tipo de contacto o comunicación con esta víctima hasta que el juez ordene lo contrario.
No contact includes no telephone calls,
El no tener contacto ni comunicación incluye llamadas telefónicas
or attempting to contact the alleged victim through a third person.
o intentar contactar a la supuesta víctima a través de un tercero.
Since it appears that you lived in the same residence,
Ya que parece que ustedes viven en la misma residencia,
you'll be able to return on one occasion
se le permitirá regresar solamente en una ocasión,
in the company of law enforcement
acompañado de un oficial del orden público,
within 48 hours of your release
dentro de las primeras 48 horas después de su liberación.
to obtain any personal items that you may need.
Esto es para que usted obtenga artículos personales que pueda necesitar.
You need to stay away from the victim by at least 500 feet.
Tiene que mantenerse alejado de la víctima por lo menos 500 pies de distancia
And not go anywhere that you would anticipate the victim being.
y no ir a ningún lugar donde usted anticipe que la víctima vaya a estar.
Ujú.
Ujú.
Okay. Okay, sir. Thank you.
Bien, señor, gracias. Eso es todo.
Okay. Next one.
El siguiente,
Martinez.
Martínez.
Martinez. Let me find that here. That's the name. Have Emilia Martinez.
Emilia Martínez?
Sí.
Yes.
You have a lawyer, or would you like to have one appointed?
¿Tiene usted un abogado o quiere que se le nombre un abogado?
Yo nombraría uno.
To have one appointed.
I will provisionally appoint the public defender's office to represent you.
Provisionalmente le voy a nombrar a la oficina de abogados de oficio.
You're charged with knowingly driving while your license was suspended or revoked.
Se le acusa de manejar a sabiendas con licencia suspendida o revocada.
And there is probable cause based on the affidavit.
Basándonos en el informe policíaco, sí existe causa razonable.
And this is an M2
Este es un M2,
It's them ones.
M1.
es un
Okay,
M1.
We'll be setting the bail amount at $1,000.
La fianza se fija en $1,000
And a lawyer is being appointed for you.
y se le va a nombrar al abogado de oficio para que la represente.
Okay, the next one.
Siguiente. Puede sentarse, señora.
Reyes Silva. Reyes Silva.
Reyes.
Reyes Silva?
Sí.
Yes.
Okay. Reyes with an R.
Yes, sir. Central County.
Okay. And this is Mr. Juan Carlos Reyes.
¿Este es
Sí.
Juan Carlos Reyes? Yes.
Mr. Reyes, would you like to have a lawyer appointed?
Señor
Sí.
Reyes, quisiera usted que se le nombre un abogado y espere por favor a que termine la intérprete de hablar.
I'll provisionally appoint the Public Defender's Office to represent you.
Provisionalmente le nombro al abogado de oficio para que lo represente.
Sir, you're here on an arrest warrant
Usted está aquí debido a una orden de arresto
for failing, for violation of probation.
por incumplir su probatoria.
The judge issuing the warrant indicated it's to be no bond.
El juez que emitió la orden de arresto determinó que era sin fianza.
You'll be taken in front of the probation judge at the appropriate time.
A usted se le va a llevar ante el juez encargado de los casos de probatoria en el momento adecuado.
Thank you, sir.
Gracias, señor.
Sarmiento Perez Jensen.
Sarmiento, Pérez,
It is
Génesis,
ARMI. It is a female.
Dealing with, looks like,
parece.
it's Denises Sarmiento Perez.
Génesis, Sarmiento, Pérez?
Sí.
Yes.
You have a right to have a lawyer.
Usted tiene derecho a tener un abogado.
Would you like to have a lawyer appointed?
¿Quisiera usted que se le nombre un abogado?
No, yo voy a conseguir uno.
No, I'm going to find one.
Okay, you're charged here with driving while your license was suspended or revoked.
A usted se le acusa de manejar con licencia suspendida o revocada.
But there is also an ICE hold. An ICE detainer has been issued for you.
Y también existe una orden de detención por parte de ICE, Inmigración. Se emitió una orden de detención en su nombre.
ICE will be made aware of your availability.
Se le va a dejar saber a ICE acerca de que usted está aquí disponible.
So you'll be held for ICE.
Así es que la vamos a mantener detenida para que venga ICE.
I will set bail at $1,000 on
Y,
the charge you face here.
y en cuanto al cargo que usted enfrenta aquí, voy a fijar la fianza en $1,000.
Thank you, ma'am.
Gracias, señorita.
Okay, who else? Next,
Siguiente.
That's all we have.
that's all you have. Ms. Hernandez, do you want to make an announcement to ask if anybody else might need the services of an interpreter?
Yes, Your Honor, thank you. Buenas tardes. ¿Hay alguna otra persona que necesite intérprete en español? Por favor, levanten la mano si es así.
Hey, we have one at South China. He said he's hard of hearing. He can see, but he can barely read.
What is that gentleman's name?
Last name is Barideault. First name Kyle.
Over the B.
I did not.
First name, last name is with a B.
It's Kyle,
Yeah.
Barr. Let me get this one here. I have it on the screen for you.
And he needs a,
But he
needs a
does
Spanish
speak English?
interpreter.
No, I'm guessing sign language. You know sign language?
The name
Oh,
doesn't sound like it, but
He don't even know sign language.
He's just hard of hearing.
Does he need the closed captioning thing?
He can't really read.
Do they have one of those headphone?
Do they have any headphones or anything we can put on him?
No, sir.
And he doesn't read and cannot hear.
He might have to be brought back when they can get one of the headsets like Central has. I'm not sure.
Could you have?
Or you can let the bailiff know what you're saying and then the bailiff could interpret to him what you just said. I mean, if I don't know how else to do this.
Can he hear, can he hear? Where is he? Have him step up to the podium. Can he hear, can you communicate with him?
Can you hear him?
Yeah, I can hear him.
Can you hear me?
Yes, sir. I'm just gonna go like this so I can hear you a little better.
Okay, and what is your last name?
Venerable?
And it's Kyle?
Yes, sir.
Okay. Sir, you are here charged with domestic violence battery. You have a right to have a lawyer. Would you like to have a lawyer appointed?
I'll take a public defender, but I was told to plead no contest.
Okay,
Because
well,
I
that's
want to
fine.
fight it.
I'm going to appoint the public defender's office to represent you at this point. I've
Okay.
looked through the probable cause affidavit, and there is probable cause to have you under arrest. I am going to set the bail amount, this is an M1, at $1,000 as a condition of pretrial release. Pretrial release, you'll need to report to pretrial services upon your release. You'll need to report to pretrial services at least twice a week as directed. And there's some general conditions that apply to everyone on pretrial release: no criminal activity, no possession of illegal drugs, not leaving the state without permission, not driving without a valid driver's license. I'm also including condition 16, not to possess, carry any type of firearm. Condition 17, you're prohibited from having any contact with the victim. No contact means no cards, no letters, no telephone calls. Even while you're in custody, you may not call. And once you are released, you must stay at least 500 feet away from this victim. If you were in the same household as the victim, then I will give you permission to go to the house within 48 hours in the company of law enforcement, which you'll need to arrange to obtain any personal items. Otherwise, it's staying away from that person until further order of the court.
Okay.
And that will be it. Stay away 500 feet also. Okay, sir?
Okay.
Your public defender will be able to communicate with you and give you some more or answer any questions you might have.
I only got a video of what I have of evidence.
Okay,
Because
you can talk
I
to your
was
public
defending
defender
myself.
about that. Thank you, sir.
Okay, thank you.
Okay.
may the interpreter be excused, Your Honor?
Yeah, thank you, Mr. Hernandez. Thank you.
You're welcome, Your Honor. May you have a good day.
Good afternoon,
Good
Judge.
afternoon.
And I have two matters before the court. First one is Mr. Feritz, Pedro Feritz.
Which?
That's FERR.
And it's in
I'm not sure which jail he's in.
Central, apparently. Okay, this is Pedro Feritz. And let me just look, what I have here is that this appears to be an add-on charge.
Correct, Your
I
Honor.
was looking through this, it appears that Mr. Feritz has had an additional charge of grand theft added.
That's correct, Your Honor. He initially bonded out on criminal mischief. It appears that the state has changed that criminal mischief into a grand theft. He's bonded out, I think, on approximately 7 other charges, or is it 8 other charges?
8 other charge.
Yeah, 8 other charges, yeah. So, Your Honor, at this point, based upon the fact that he's already bonded out and it was an add-on, we request an ROR on this matter.
What is the state's position? This,
The standard bond for a third-degree felony is $5,000. That's the amount recommended on the capias. That's what the state recommended.
the capias sets the bond. I think you'll have to take that up with since the capias includes the $5,000 bond amount, I think you'd have to take that up with the judge that issued the capias. So, but that's what it is, just an additional charge, so you're aware of that.
Yes, Your Honor.
It's previously placed on pretrial for the same case. I didn't know if you wanted
Okay,
to add.
he's releasing the same pretrial conditions in regard to this count as the others.
Yes, Your Honor. The next matter I have is Devon Harris.
Devin Harris.
Devon Harris is with us, and this is a warrant that was issued on apparently alleged violation of probation. And Judge Cumby indicated a no bond hold.
Yes, Your Honor. At this time, we request the earliest date in front of Judge Harb that we can obtain.
That will give you a date in front of Judge. Do you want this paper?
I have it.
That's Mr. Harris. Mr. Harris, your attorney is aware of this, and we're going to get this over in front of Judge Harb, who's the violation of probation judge, as soon as we can.
Okay.
June 15th.
Yes, Your Honor. Thank you.
Is that all you have?
That's all I have, Your Honor. Thank
Okay,
you.
Next.
Same. I don't know.
Good afternoon, Trinidad Perez on behalf of Colton Woody.
I'll ask to be heard on this one as well, Judge.
That's what.
I will ask to be heard on this one as well, please.
This is
Woody, is it central?
that's central.
It's central.
Okay. Ron, I would waive the reading of the charges. These are additional charges added on. This is the first appearance.
Okay, Quentin Woody is with us,
Woody.
and third degree felony charged here.
He's covered for the back. Yeah.
State indicated his desire to be heard.
Your Honor, honoring the request from defense counsel, there are 5 counts before the court. There are additional counts that are similar to the ones on the docket for today. Spoken with the case filing agent. My understanding is in the other counts that are similar, the accused has already been ordered to be placed on a GPS monitor. The state would respectfully request that that be a condition of any bond for the counts before the court today. I would note that the defendant also has an open case. I believe it went to first appearance on Sunday. While it is a different charge, it is in a similar vein, I would say. Again, trying to honor what the defense counsel requested. That was under NM 264086. Also, I would note that the accused has been convicted of the same crime in the past. In CF 172061, in that older case, he was, among other things, put on probation and was violated on that probation for essentially tampering with a tracking device, with a GPS device. So the state would respectfully request enhanced bond on each of these counts. The typical bond for an F3 is $5,000, and we're requesting GPS monitor on these counts as well. Thank you.
Was he already on pretrial release with the GPS?
Yes, Your Honor, that's correct. We are just asking for the standard bond of 5,000 based on additional counts. It has to do with the same alleged incidents, same dates.
Okay, it's 5 counts of it.
Yes, Your Honor.
Okay, so what I'm going to do is bail him out at $5,000 per count.
Yes, Your Honor.
As a condition of pretrial release, all the conditions of pretrial release earlier in place on the other case will remain in place on this case, along with the GPS monitor.
Yes, Your Honor.
And Mr. Woody, let me just say that those GPS monitors, there's an allegation that you've played with one in the past. Don't do that.
I did not.
Well, I'm just saying that's the allegation. I'm not
Okay.
saying
Anything, we'll be in contact with their family.
it did or didn't, but that's the allegation. So just don't mess with the GPS monitor.
Thank you, Your Honor.
Yeah.
Good afternoon, Your Honor. Denise Sokolev, I'm here for Zachary Urban. You?
And in Central.
He's at South County.
My understanding that he was reset from yesterday so that I could be here.
Okay, let me find that here. Zachary Urban is with us, and what I have is a violation of probation order issued out of Hernando County. And it indicates a no bond hold for him to be held for a court.
Yes, Your Honor. I've been in correspondence with Mr. Harris, who is the assigned state attorney. They will be announcing a dismissal. It's just a matter of getting him in front of Judge Harb. I've already reached out to the JA to try to get something as soon as possible, given the circumstances. I understand the date that this court has is that June date. I'm fine with that as a placeholder. I'm hoping to get it earlier, so.
So he'll be taken in front of Judge Harb.
Yes. Is that the date or?
No, this is just a paperwork.
Oh, sure. Thank you. If I may approach. Thank you.
Ain't throwing things away. Use it.
Yes, absolutely. Thank you. I appreciate it.
Okay. Thank you.
And it was a June, do you have the date?
June.
June 15th, and I'm working on something sooner. Thank you so much. Have a good rest of your day. Yeah, June date. See you.
Thank you.
Judge Edward Schwab here, appearing virtually for Ryan Ozuna.
Approaching at Central.
Last name is Schwab.
Edward Schwab, yes.
How's it pronounced? Ozuna? Ozuna?
Ozuna.
It's Ryan.
It was rolled from yesterday, so I could attend here. Mr. Ozuna, go ahead.
What I'm looking at is there is a warrant issued by Judge Harb for alleged violation of probation and him to be held no bond until he can be taken in front of Judge Harb.
Yes, Judge, we've already secured a hearing date in front of Judge Harb for next Tuesday. My client is aware of that.
Okay. Anything else I need to address at this point with him?
No, Judge.
Appreciate your patience there.
Thank you very much.
And that was resumed. Okay. And is that all for private attorneys? Okay, should we go to South County first? Okay, now, next we're going to go to South County and try to go down a little bit in order at this point. Just to let you know, I sat and spent quite a long time going over all of these and trying to get them in some order so we could move through it quickly. That hasn't worked as well as I'd hoped it would. But the first case we're going to call up out of South County is in regard to Joshua Andrews.
Sanderson Appellate Defender's Office. I do want to waive the reading of his one first-degree felony charge that he has against him.
And I'll ask to be heard as well, Judge.
Okay. What I have here, and that is Mr. Andrews there, and the public defender's office, if not appointed, is appointed at this point, and the state says it wishes to be heard.
Honoring the request of defense counsel, the charge before the court is a first-degree felony punishable by life. The court has the authority to hold the accused no bond as the defendant is not entitled to a bond on a PBL or higher. The state is asking the court to hold the defendant no bond. If the court is not so inclined, then the state will announce an intent to file a motion for pretrial detention under 907.041 and ask the defendant be held no bond until tomorrow so that we can file that motion. If the court holds the accused no bond today because of the level of the charge, we will not need to bring him back tomorrow for the state to file that motion. Thank you.
I'm just going to defer to Your Honor on this decision.
What I'm going to do is, in light of the nature of the charge and the state's indication that they would most likely be filing the motion for pretrial detention, I'm going to hold him on a no bond basis at this point without prejudice that a motion can be filed in front of the judge to whom this will be assigned. So, sir, what's going to happen at this point is this case is going to be placed in the front of another judge, assigned to another judge. At that point, that judge, I'm giving that judge the authority to reevaluate with more information than what I have here presently in front of me, and your lawyer to have an opportunity to further do some research and aid of seeking a bond amount. But it'd be a no bond hold at this point. There is probable cause based on the affidavit.
Yes, sir. It's a warrant with conditions. Do you want to just let the next judge do the condition?
Yeah, it'll be leaving it, the conditions, well, those conditions are set forth. There no possession of firearm, no contact whatsoever, stay 500 feet away, GPS monitor, but all those would be subject to the condition that would be issued by the judge if they decide to let it.
So just leave it for the next.
Leave it for the next judge. Okay. So, okay. Next. Pardon me? Didn't the public defender say they were?
Well, I just speak on behalf at the beginning to waive the reading. I don't know if he actually won the public defender.
I will point the public defender since you've in essence of that. I appreciate it. Thank you. Okay, next case we'll call up is looks like Taki Burton.
I'll ask to be heard on this one as well, Judge.
And spell, pronounce your first name, sir.
Sakai Button.
Okay, and sir, you are here, okay, the charges that you're here on are a petty theft, aggravated assault with a deadly weapon without intent to kill, robbery by sudden snatching, kidnap with inflicting of harm or terrorizing a victim, battery by strangulation, tampering with with evidence in a first degree proceeding, and a repeat dating violence. Looking at this, there was a warrant issued for your arrest on these charges. I've looked through the affidavit in addition to seeing the warrant, and there is probable cause. Would you like to have a lawyer appointed, sir?
Yeah, I would like to put my own word, please.
I will appoint the public defender's office, and the state said they wish to be heard.
Thank you, Your Honor. With regard to the aggravated assault, the deadly weapon, and the kidnapping charge, each of those is an enumerated dangerous offense under 907.0415A. The state on those two counts is filing a motion for pretrial detention and providing a hard copy to appointed counsel. May I approach?
You may. Thank you, sir.
State respectfully requests the court review this motion. And if the court finds it facially sufficient that the accused be held no bond on these two counts, pending a hearing on this motion, which should be set for next Tuesday at 1 p.m. on the A2 docket. Thank you.
Okay, one question I had in looking at this, as far as the probable cause, the kidnapping aspect of it, I was a little concerned about. Because it talks about, reading through this,
The allegation is the accused forced the victim back into the car and drove her around against her will after threatening her with a firearm.
forced her back into the car. Okay, so this is one, there was a number of different things that appeared to have been going on.
That is the allegation, yes, sir.
Okay, and that's what I was trying to, I do find that there's probable cause. I'm appointing the public defender's office. There is probable cause set forth here. I do find that the motion for pretrial detention is legally and procedurally sufficient to allow the state the opportunity to further argue their motion for pretrial detention. I will grant that motion, schedule this for next Tuesday in front of the whichever judge will be handling it on that day. So I am appointing the public defender's office. I'm sure they'll be having somebody communicate with you as far as what's going on, sir.
Your Honor, I would ask that bonds be set on all the other charges. The state only filed their motion on 2 counts.
I'll set the bail amount on the petty theft at $250, the aggravated assault with a deadly weapon.
That one is pending the hearing.
That's pending the hearing.
Yes, sir.
And then the robbery, setting, snatching, I'll set it at $5,000. Kidnap as part of the motion. The battery by strangulation, $5,000. Tampering with the, and that's throwing the phone.
Yes, Your Honor. I'll call it law enforcement. That's a first-degree felony.
It's a third degree, right?
First.
The first degree felony because of the nature of the kidnapping charge.
Yes, sir.
Okay. At this point, again, without prejudice for a judge to take into consideration at the detention hearing, I'll set that amount at $25,000. And the sexual repeat violence, what's the end?
Judge, that's a qualifier that is added to indicate that the battery charge also qualified as a domestic relationship. Does not change the level of offense, but if convicted, it does change some of the sanctions at sentencing, but it is not something. But because of that distinction, the state would request pretrial release supervision with an order of no contact with the named victim.
Yeah, I was going to go into that. So that would be, I'll set that bail amount at $1,000. All of this is a condition of pretrial release, against without prejudice for a subsequent judge to address this. But the pretrial conditions will include the standard ones of 8, 9, 10, 11, and 12. There will also be 16, no possession of firearm, 17, prohibited from having any intentional contact with the victim. No contact means that, no cards, no letters, no telephone calls, no emails. Even while you're in custody, you may not contact that person either directly or through any third person. And you're not to have go within 500 feet of any place that person will be it school, work, home, or anywhere else. Again, without prejudice for the judge handling this to further evaluate what needs to be put into place.
Your Honor, Sanderson's Public Defender's Office, the dating repeat sexual violence is not even a charge. It's just there as a qualifier. So I would ask
so that
ROR on that, since it's really not a charge. It's just on there. I mean, it's not bond.
a charge.
Agreed, Judge. It's just to alert the court that there was a domestic relationship alleged.
Okay.
I think I heard you said 1,000 on it, but it's not a criminal.
So I just-
For the college day, did you want to?
Twice a week.
Twice a week, okay, did you? All the.
Okay, next case we'll call up is in regard to Skylar Chatterton.
Yes, sir.
Okay, Mr. Chatterton, you are here with a capias, which is in essence a warrant, a failure to appear. The bail amount, the bond amount is set at $1,000. You failed to appear for an arraignment. So if you bond out at $1,000, you need to make sure you know when you need to be back in court. Did you have a lawyer in the underlying or this case?
What is this case regarding? Is
Petty
it?
theft.
No, I did
Okay,
not.
I'll wish to have a lawyer appointed.
Yes, sir.
I'll appoint the public defender's office to represent you. Again, your bail amount is $1,000. If you do make that amount, you need to make sure you know when you're due back in court and get in touch with the public defender's office if they haven't gotten in touch with you by the time you were released.
Yes, sir.
Okay? Okay, thank you, sir. One real quick thing while I'm thinking about it. For all of you, just to listen up to this. If you are released from custody, you need to make sure you get some information as to when you are due back in court. You can see from what goes on here that a number of times people are, a warrant or a capias is issued for their arrest because they failed to appear for something. So it's a matter of knowing when you're due back in court every time you leave custody or every time you leave a courtroom. The other thing is I'm appointing the public defender's office on a number of these cases. I strongly urge you to stay in touch with the lawyer that's assigned to your case. These public defenders work very, very hard at their jobs. And if you don't stay in touch with them, it makes it very difficult for them to, to help you through and navigate through these cases. So please stay in touch with your lawyer if one's appointed for you. Next, we'll call up in regard to, it looks like Garary or Carlton Garary. Is that Mr. Garary there?
Yes.
Hey, Mr. Garary, do you have a lawyer or would you like to have one appointed?
Well, I'd like to have one appointed.
I'll appoint the public defender's office to represent you, sir. You're here charged with possession of cocaine, possession of drug paraphernalia, and resisting an officer without violence. I've read through the probable cause affidavit, which I have in front of me, which sets forth probable cause for your arrest on these charges. What I'm going to do is set your bail amount at $5,000 on the first count, possession of cocaine, and $1,000 each on the other two counts. If you make the bail amount, you need to again stay in touch with your lawyer and know when you're due back in court, sir.
How much is the bail, sir?
The total amount is $7,000.
700.
7,000. Which you can bond out by getting with a bonding company on that.
Yes, sir.
Okay, thank you, sir. Good luck to you.
Who's on?
There's a big difference between bail and bond.
I don't, Judge.
Bail is the amount. Bond is how you can put up the amount, either in cash or bond. We all use bond as a, interchangeably with bail.
I always have, yes, sir.
Yeah, but bail is the amount and bond is how you can, we all use them interchangeably. How's that for useless information? Huh?
Mhm.
Okay. That's why
I will know that going forward.
That's why I say bail.
Yes, sir.
Because that's the amount. Okay. Next case we'll call up is in regard to Ramsey Guzman.
Yes, Your Honor.
Morning or afternoon. Mr. Guzman, you're here charged with battering a law enforcement officer, resisting officer with violence. Do you wish to have a lawyer appointed, sir?
Yes, I do.
Okay, I'll provisionally appoint the public defender's office to represent you. I've looked through the probable cause affidavit, and there's an indication here that he might currently be on probation.
Yes, sir.
So here on the rest of the DOP. Okay, well, there it is. Okay, there's also here on a arrest for the violation of probation. What I'm going to do on the new counts, I will set the bail amount at $5,000 per count, but you're going to be held on a no bond basis to respond to the allegations of violation of probation. And again, I'm appointing the public defender's office to represent you on all of these matters, but you'll be held and taken in front of Judge Harb to address the violation of probation, sir.
Okay.
Okay, thank you, sir.
Okay.
Next, we'll call up in regard to Randall Hawes.
Yes, sir.
Good afternoon, Mr. Hawes. Mr. Hawes, you're charged with possession of cannabis, possession of drug paraphernalia, introduction of contraband into a detention facility, and resisting an officer without violence. Do you wish to have a lawyer appointed, sir?
Yes, sir.
Okay, I'm going to provisionally appoint the public defender's office to represent you. All of these are first-degree misdemeanors. We'll set the bail amount at $1,000 per charge, which is a total of $4,000. And there is probable cause based on the affidavit that I've had an opportunity to review. So if you make that bail amount, you need to stay in touch with the lawyer, but I'm sure the lawyer's office will have somebody interview you at some point very quickly, sir.
That's all.
The next case we'll call up is in regard to Rashad Hill.
Sanderson Public Defender's Office. I just wanted to point out that pretrial release on their DV victim comment sheet, they spoke with alleged victim, and she indicated she wanted to have contact with Mr. Hill. So that was just bringing that to your attention.
Okay.
And there were pretrial release conditions on the warrant. I don't recall if that's in conflict.
It's a warrant with conditions with no contact order.
There is an arrest warrant.
So the warrant is, there's an initial next to the no contact with the victim
Yes.
portion of the warrant.
Right.
Signed
And
by the judge.
that will have to, I'll have to honor that since a judge has issued that warrant. Let me just explain what's going on at this point.
Yeah.
Mr. Hill, you're charged with. Let's take a look there. But apparently there's an indication that he might be on probation himself.
He's in Polk County.
Hillsborough County.
Hillsborough County probation.
Okay, so that's out of Hillsborough, because I noticed that in there. And we haven't heard anything from Hillsborough about him. Okay. Do you wish to have a lawyer appointed here, sir?
No, sir, I'm gonna hire one.
You're going to hire a lawyer. Okay, we'll give you an opportunity to do that. And the domestic violence, what I'm going to do, did it say, didn't set forth a bond amount. This is charged in F2.
There is not a standard bond for F2s. A typical bond is usually 15,000, but again, that is a typical bond. There's not a standard one for these types of cases.
You know, I've seen bonds as low as 10,000 by some judges on F2s. It's your discretion what you think the bond should be.
Yeah. I knew it's either 10 or 15 over the past.
Or you can go home.
If you go lower.
I'm going to set the bail amount at $10,000, but have to honor the pretrial release conditions set forth in the affidavit. This is without prejudice, that it can be modified upon motion filed with the judge to whom it is assigned. And that condition is that you're not to have any contact with the victim. No contact means exactly what I said. No cars, no letters, no telephone calls, no emails, no texting, tweeting, going anywhere. There's a reasonable expectation for that person to be, and no telephone calls, even while you were in custody. I'm also going to include you not to possess, carry any type of firearm, gun, or weapon at this point, and stay at least 500 feet away from that victim. If you and the victim shared a residence at all, you'll be given an opportunity to go to the residence within 48 hours of your release in the company of law enforcement. But it appears that it's different address. So if that's not your residence, that you cannot go there at all.
Did you want me to give him number 18, which is you can return in 48 hours, or just take that one off?
Just apparently,
Since they-
looking at his address is shown in Gibsonton, and the alleged victim shows an address in Lakeland.
So we'll just take number
Just
18
take it off.
off.
I think that they're
How many times do you want to call? 2 times?
2 times a week.
Yes.
And if you're released, you need to report to pretrial services, and then you'll be given instructions on reporting to them on a regular basis, sir.
Yes, sir.
Okay, next case I'll call up is in regard to Tony Klinski. And Mr. Klinski, do you wish to have a lawyer appointed, sir?
I'm a public defender, sir.
You're very good lawyers. You are here charged with falsely identifying yourself as a licensed contractor and grand theft of property by having taken the money on the contract allegedly and not doing anything and depositing that money, looking through the affidavit. There is probable cause based on the affidavit. I am setting the bail amount at $1,000 on the false identification as a licensed contractor and $5,000 on the grand theft. If you do make bail on that, you're not to have any contact with this alleged victim. No contact means that no cards, letters, telephone calls, emails, mailing, or going anywhere near the residence of the alleged victim. That's not going to be a condition of pretrial. It'll be a condition of pretrial release, but I'm not putting him on supervision.
So, condition of bond?
It's a condition of the bond, the bond amount.
Yes.
He has previous pretrial of no contact, so we could just
leave.
add it on
Yeah,
to no contact for this charge also.
correct. No
Yes,
contact
sir.
with that person.
How many times?
Could we also add it where I can get a phone call? I've been locked up for almost a week with no phone call.
Pardon me?
I've been locked up for almost a week with no phone call. Can we add that I can at least get one phone call?
You have a right, but you cannot call. That's between you and the jail, but you cannot call this particular person.
No. I just want to call a bonds company so I can get out of here.
Okay, you should be given that opportunity by law enforcement to make your telephone.
I was never given it.
Okay, well, that deal with them that he needs to just say that he needs to be provided the opportunity to make a phone call.
Did you want 2 times calling?
Yeah, if you, I'll make this a condition of pretrial release, calling in twice. Okay? Okay, thank you, sir. You want to hear something coincidental?
Yes, sir.
Hearing this morning. Speed report. False licensing or not having a license, just coincidental. I haven't done that in 20 years. I was in there and today. So I'm familiar with the statute that relates to that.
Yes, sir.
Okay, next case we'll call up is in regard to Trunston Cruz. Or
Speaker on this as well.
Sanderson Public Defender's Office. We were appointed to his cases yesterday. Judge Gibson handled the other charges. She ordered it be brought back according to the first appearance order I just looked at on these 3 counts. She ordered the Barol with assault or battery to come back to the state to file their motion for pretrial detention. And on the and then for us to decide whether there's probable cause on the VOPs for felony battery, possession of meth. Yesterday I was telling the court I didn't believe he was on probation. Well, not only is he not on probation because it was terminated back on October 21st of 2025 in both cases. At that time, he was sentenced to year and a day prison on those cases, and he was given 236 days credit. The Department of Corrections website shows he was released from prison on April 26, 2026. So it's my position, not only is he not on probation, but this is not even an F4 case, so it asks that no probable cause be found on the it's labeled BOP on the docket, felony battery and meth, but also him to be ROR'd on those 2 counts.
I was showing that he has the criminal mischief, a burglary with an assault.
Yeah, this is a bring back from yesterday. The Judge Gibson already handled the other criminal mischief and the burglary with assault and battery. These are the leftover charges from yesterday that had to come back.
On the, but so that the criminal mischief has been taken care of?
Yes, yes.
Okay, so
Yeah, the first appearance order, if you look at it, page 2, she dictates why she's wanting these charges to come back today.
The burglary is still before the court, and that's the one I wanted to be heard on.
that's the unarmed burglary?
No, sir, the burglary with battery or assault. It's actually burglary and assault. It came in on the affidavit with burglary, because it's the same statute, it said burglary with assault or battery twice. It's really a single burglary with both an assault and a battery. Yesterday, I stipulated to release on one count, but not on the others. The other is a qualifying dangerous offense and is also a PBL.
Okay,
With regard to BOPs, I agree that CF 264924 appears by all inspection to be a closed case. Whether the state proceeds on a violation is still a future issue. I think we won't, but that is a future issue. With regard to whether to hold him on that today, I think, the state would stipulate to releasing him on his recognizance for the violation of probation allegations. I'll still ask to be heard on the burglary.
And so we're talking about the burglary with an assault / battery that's alleged in just one of the probable cause affidavits.
Yes, sir.
It's the only one that's brought back from yesterday in the new charges.
I just had all those.
Yeah.
Yes.
And she dealt with everything yesterday, except she ordered for these 3 charges to be brought back today. So we're only here reviewing.
What's the state's request in regard to the charge of the burglary with assault or battery?
Judge, that is a first-degree felony. It is punishable by life. The accused is not entitled to a bond because of the level of offense. The state is requesting the court hold the accused no bond pending further proceedings, but holding him at first appearance. If the court is not inclined to hold him no bond, then I will be filing a motion for pretrial detention and setting the matter for a hearing forthwith.
And my understanding was the state was supposed to file the motion for pretrial detention today. I mean, that's what the first appearance order said, but
I think you have the authority to do either, Judge. That's the state's position.
Yeah. I'm going to grant at least at this point, oral motion. I think that you're setting forth that this is the first degree felony punishable by life, and that and I was supposed to be in writing.
well, I mean, that's what the judge yesterday, we went through this with he went through this with the judge yesterday, and she said that she was going to continue it for him to file his motion for pretrial detention. And that's the only reason it's on the docket today, is my understanding. And again, I just read the first appearance information from yesterday to remember exactly what happened. It's in the showcase.
You see, I don't know how to.
And the first appearance order is actually already there, and it says what happened on this case yesterday.
I can show you the.
Yes. It's in the showcase.
Why I'm just showing it.
Okay, just say that to be brought back today to file motion for pretrial detention, which indicates seemingly that he should have filed one by today.
And certainly I can, Judge. Again, my position is simply that it is before a first appearance judge, and the state's position is you have the authority to hold them based on the charge, even though it came over from yesterday from a different judge in the first appearance courtroom. If the court is not inclined to do that, then I will be filing a motion for pretrial detention, and that will trigger a hearing on that motion for next week.
We would end up at the same spot.
Well, actually, he would have a hearing on it and a chance of getting a bond on it next week if he files a motion for pretrial
Right. I
detention.
think that would be, I'm going to go ahead and grant what was represented as the desire to file that motion, granted on an oral basis, that on the pretrial detention, so that the hearing can be held next week. I think that brings things up quicker than they otherwise would, If I held them on no bond basis pending determination by the judge to whom it's assigned, it's going to be much farther down the road.
Typically, that would be an Arthur here. Yes, sir.
Okay. Okay, so bottom line is you have an attorney from the public defender's office, which is representing you, sir. And you'll be taken in front of a judge next week with an opportunity to further argue the opportunity to be released on a bail amount.
May I approach with that motion, Your Honor? I have a hard copy for appointing counsel.
Okay, thank you. Okay, so the motion's being filed, Your Honor. So the hearing was, when would the hearing be?
Tuesday at 1 o'clock on the A2 docket, please.
Okay, so it has filed a motion.
If the court, yes, sir. It's a one thing follows the other. So the purpose was not to be pedantic, but to be sure that the procedure was clear.
Yes. Okay, so you'll be in front of a judge next week, sir.
And then, Your Honor, is he going to be ROR'd on the other 2 counts that he's not even on probation for? Or
Correct. There's ROR on those because apparently that is moot.
he's already done his urine a day on it once he violated the probation? For Coons?
Okay, next we'll call up. It looks like Dominic Massie. Okay, Mr. Massie, would you
Yes.
like to have a lawyer appointed, sir?
No, I'm hiring my own.
How you're on, okay. What you're here on is several charges. One, willfully refusing to accept and sign a citation. Another, leaving the scene of a crash without giving information. Providing false identification to law enforcement and resisting an officer without violence. I've looked through the probable cause affidavit, and there is probable cause for these charges. I'm setting the bail amount on the resisting an officer without violence at $1,000, giving false identification to law enforcement, $1,000, refusing to sign a citation at $250, and leaving the scene involving a crash involving property damage at $250.
Hey, Judge Jacobson, we skipped Lee Brown, Lee Brown. We skipped last name Lee. You done.
Okay, I'll see if I can find that. I might have missed that in the paperwork over here. And that was Lee Brown. Brown Lee.
So.
See.
That name starts with an L. Mr. Massey said he would hire an attorney. Oh.
Okay, that was, we put it on. It showed up over in Central. And that wasn't me, that was the notations. That's highlighted. Okay, so, and Mr. Brown is in South then? Okay, and is that Mr. Joseph Lee Brown standing there?
Yeah.
Okay, Mr. Brown, you are here charged with grand theft and unarmed burglary of an occupied structure. You have a right to have a lawyer. Would you like to have a lawyer appointed, sir?
Yes, sir.
Okay, I will appoint the public defender's office to represent you. I've had an opportunity to review the probable cause affidavit of what allegedly occurred at the CVS. I'm again finding there is probable cause.
Yeah.
And let me just.
If let me have just.
And what I'm going to do is in regard to the grand theft, set the bail amount at $5,000. The armed burglary charge is an F1 in this. An unarmed burglary of an occupied structure.
Doesn't, I kind of look at it now. Yeah, just.
I don't know how it can have one.
Yeah, because this was occurred at a commercial establishment, allegedly.
I may have just a minute. The document I had scanned was not the one I need.
That's what it says there.
Yes, sir, on warrant and the update, it shows.
Usually they're in F. Hold on.
And that's, I did see that the warrant had F1, but.
The warrant says just one. As does the affidavit.
Just. May I view the affidavit the court has in the documents I have access to? I don't have an affidavit.
Here.
Thank you, sir.
I just think they this mark.
I'm gonna staple.
It's my bad.
I appreciate it, Judge. Not. Was there an enhancer cut? Usually that's an F2, right? Well, regardless, I appreciate it, Judge. Thank you.
At this point, what I'm going to do is based on my review of this, I'm going to find probable cause to have charged it as an F2, set the bail amount on the F2 at $10,000, on the F3 at $5,000. And that's going to be as a condition of pretrial release that he has no contact with any CVS store whatsoever. I think this would.
Would be number 17, and there is.
And true, and no contact with the co-defendant. So apparently there's a co-defendant by the name of Bryant Theron or Theron. There'd be no contact with that person. No contact just means that no cards, no letters, no telephone calls, no contacting that person through any third person, no communicating with that person whatsoever. And I'm appointing the public defender's office to represent you, sir.
Thank you.
Is that what we stay with 2 times? Okay. That's up to you on something like this. Normally. Okay, sounds good.
Okay, next case I'm going to call up is in regard to Dominic Massie.
We did him.
Who's on him?
Yes.
Oh, I didn't write her.
We just did him. We went back because we skipped one.
Okay. The next person will be Corey Allen Mole.
I'll ask to be heard on this one, Judge.
Pardon me?
I'll request to be heard on this one, please.
Request to be heard. Okay. And Mr. Mole, would you like to have a lawyer appointed, sir?
Yes, sir, I would. And I know no, sir, I just want to say that 2 days ago, my mother passed away, and I'm her next of kin, and I know what my charge is, what they said, but I have 2 witnesses and it's complicated.
Don't discuss the case. I've told you not to discuss the
case.
Yes,
sir, I know, but
I'm appointing the lawyer to represent you. The lawyer can file whatever motion might be appropriate.
I'm at the mercy of a bond, sir. I really need to get out to finish my mom's funeral burials.
I appreciate that. What I'm looking at are some very significant charges, however. And let me just take a look at this for a second.
But there is an open investigation on the man who said that alleged that I hit him or whatever for a homicide investigation for the death of my mother. There is an open investigation, and I told the detectives last night.
Okay, you can discuss this with the lawyer. What I'm looking at is the paperwork concerning what you were charged with here, and that's what I'm trying to look back at. I read it earlier. I'm refamiliarizing myself with what I'd read.
Yes, sir. I'm asking for mercy today.
They said they wish to be heard on this.
Yes, Your Honor. The defendant is charged with a first-degree felony punishable by life offense. Not getting into the facts of the case unless the court feels it's necessary. The defendant is not entitled to a bond. The court is requesting that the court hold the accused no bond as he is not entitled to one. And this is a PBL. It is a burglary of a dwelling charge, so it is a qualifying dangerous offense under 907.041. If the court is not inclined to hold him no bond, then I will request he be held till tomorrow and be brought back for the state to file that motion for pretrial detention. But for today's purposes, because of the level of the charge, the state is requesting he be held no bond until further proceedings. Thank you.
Sanderson, Public Defender's Office. I would ask for a bond to be set based on the circumstances of this case. It does reference his mom dying on May 18th in the actual police report. And he, in the police report, it does say they talked to him and he denied that he did what the alleged victim is saying that he did. And of course, his mom did die on May 18th, according to the police report. It is discretionary actually on a PBL charge. It's different than a life felony of whether the judge wants to give the bond or not on a PBL charge of first appearances. If Your Honor was inclined to hold him no bond, that's one matter. But if Your Honor was inclined to give him a bond, then I would ask for the state to file their motion so we could get a hearing and get a quicker bond on this case.
I'm going to grant the state's motion to hold it over to tomorrow to file a motion for pretrial detention. That will also give the defense an opportunity to further kind of look into whatever's going on. I mean, looking through this was kind of a convoluted scenario that was describing what was going on with them. So I think the better part of discretion is what's going to happen, Mr. Mola, is I am at this point deferring till tomorrow for the judge to file, for the state to file a motion that will have an opportunity to have a further hearing on it. I'm appointing the public defender's office to represent you. They will probably be in a better position to argue on your behalf concerning earlier release than I have information to deal with today. So I'm going to grant the state's motion to hold this over to tomorrow for them to file their motion.
Okay, so I kind of don't understand about tomorrow. So would I be able to get a bond tomorrow? Is that what you're saying?
Possibly, yeah. I'm going to allow the judge that would be hearing it tomorrow. There'll be a little bit more opportunity to look at the situation and from the defense point of view, to be able to better argue their position rather than try to do it today with not as much information as I would want if I were defending this. So I'm going to hold it over until tomorrow to allow the state to file their motion, and a determination will be made then, sir.
Okay. Thank you, sir.
Sure. Thank you. Next case we'll call up is Bobby Nims. Mr. Nims is approaching. Mr. Nims, you're charged with resisting an officer without violence. You have a right to have a lawyer. Would you like to have a lawyer?
Yes, sir.
I'll appoint the public defender's office to represent you. I'm looking through the probable cause affidavit. And there is probable cause for what is alleged to have occurred after the law enforcement showed up to investigate what was going on. I am setting your bail amount at $1,000 on this alleged first-degree misdemeanor of resisting an officer without violence. Again, there is probable cause set forth in the affidavit. So if you make that bond, make sure you stay in touch with the public defender's office, sir.
All right.
Thank you.
All right.
Next case we'll call up is in regard to James honor or owner.
It should be Gilbert Rainey.
Is that James owner?
No, it should be Gilbert Rainey. Next up at South.
Okay, what about I have on the list there, a James Donnell owner, O-N-N-E-R.
He's at Central.
Oh, he's at Central.
Yes, sir.
Okay, that wasn't. I'll come back then. So the next case I have here is in regard to Gilbert Rainey.
Yes, sir.
Okay, and Mr. Rainey.
Yes, sir.
Looking through this, it appears that there was an active warrant for your arrest issued out of Hillsborough County, indicating that you're to be held on a no bond basis until you can be transported over to Hillsborough. So that's what you're dealing with here. You've got Hillsborough County would be made aware of your availability and will make arrangements to come get you, sir.
Yes, sir.
Okay, well,
That's it.
what will happen so we don't lose you in the system is you'll be back. What we'll do is, and so we don't lose you in the system, is have you back here in a week just to make sure that you're not lost in our system.
Back here in a week.
Yeah. Yes, sir. Thank you, sir. Okay, next we'll call up Mark Rash. Mr. Rash, you're here charged with resisting an officer without violence, first degree misdemeanor. You have a right to have a lawyer. Would you like to have a lawyer appointed, sir?
Yes.
Appoint the public defender's office provisionally to represent you. I'm looking down through the probable cause affidavit, which I've had an opportunity to review earlier. Refamiliarized myself with it. And again, you're charged with resisting an officer without violence. And there appears to be probable cause. I am setting your bail amount at $1,000. Okay. Next, we'll call up, it looks like Josu Ivan Wildan Lopez.
Yes, good afternoon, Your Honor.
Good afternoon, sir. What I have in front of me, sir, is a warrant for your arrest issued out of California. It indicates that you're to be held on a no bond basis. I'm sorry, it says defendant to be admitted to bail. Total bail. Defendant bails. Okay, there is a warrant for you out of California. And it's kind of confusing as to it says defendant to be admitted to bail. And it looks like the total bail amount is $50,000.
What's on the screen here? It says the warrant comes from municipal extradition. They will pick up.
They will pick up. Okay, well, you know, just looking at the warrant itself, and it has on it. Let's see what I'm saying. It's got the check of defendant to be admitted to bail. Oh, down there. Okay, that's what do not release. Unsigned promise to appear. Yeah. It's up here in the.
Yes, sir.
There it says $50,000.
So I guess that would bail is 50,000.
Yeah, because there's a check. Yeah, I'm looking at, what I'm trying to do is interpret a form that's been sent to us by California. And this appears to say that there is a warrant for your arrest, that California's been notified, they're already planning on coming to get you. And they've set your bail amount at $50,000. So if you made the bail amount of $50,000, you still have to make sure you make your way to California to honor this, but this warrant indicates that they'll pick you up and your bail amount is set at $50,000.
And is he hiring a private attorney or does he need public defender on this?
Do you wish to have a public defender appointed? What will happen is you'll be held and taken in front of Judge Harb on a periodic basis just to make sure they come to pick you up. Do you wish to
Yes.
have a lawyer appointed?
Yes, Your Honor. I have a paid attorney and I spoke with him yesterday and I was postponed for today.
Okay, you hired a lawyer?
Yes, I have a lawyer, a paid attorney.
Okay, so he has his own lawyer. Thank you. Okay, thank you, sir.
Yes, Your Honor. Have a good day.
Next, we'll call up in regard to that was his name is Ronald White. They will call up Ronald White.
Yes, sir.
To be heard regarding bail, Sanderson for the public defender's office.
Mr. White.
Yes,
Yeah.
we got this point, but I do want to argue over bail.
Okay, what I'm looking at on Mr. White, though, is a warrant that's been issued.
Yes, Your Honor, but if you look at the warrant, it's financial reasons only, which he owes some money. And again, make this argument all the time that it's my understanding we don't have debtors prisons here. I'm not sure why the no ROR wasn't signed or at least a bond given when all you're violated for on your probation is you didn't pay money. I mean, you can be violated for this, but it should be like a notice to appear or something. And then if you fail to appear for court, then get the no bond. But I don't understand why it's starting out no bond when he's just ordered, he just didn't pay money.
I understand, but what I'm looking at the judge having issued an order.
Right.
With a no bond provision, which I really need to honor. And no bond hold that needs filed. This can be put in front of Judge Harb very quickly. And I'll appoint the public defender's office to represent Mr. White. But Judge Harb has indicated a no bond hold for him. Failing to make restitution, failing to pay, you're right, it just sets forth amounts. But I will honor Judge, and like I said, I looked through it and Judge Harb indicated a no bond hold. So can we set it as quickly as next Tuesday in front of Judge Harb? Well, what is it? I think he has Monday, Tuesdays, and Wednesdays.
Yes. Yeah, I would ask for an earlier court date because of the alleged violations.
I agree. So can we set it next week in front of Judge Harb? I'm appointing public defender's office so that you can get on it and I think probably Doug Jackson, let him know what your argument is.
It looks like it's only Tuesday next week or a week after on the first. It'd be around.
Just do it next Monday is the holiday, so next Tuesday. Set it next Tuesday.
Okay.
We're going to try to get you in front of the judge who issued this warrant as quickly as we can. Be next Tuesday, sir.
Thank you.
No, thank you. Okay, and next we have Ira Williams.
How you doing, sir?
Thank you. Mr. Williams, you're charged with 2 first-degree misdemeanors, misuse of the 911 system and giving false information to law enforcement concerning an alleged crime. I have had an opportunity to review this. Do you wish to have a lawyer appointed, sir?
No, sir, not if needed, no.
Pardon me?
No, sir, not if needed, no.
Are you going to hire your own lawyer?
No, sir. Probably I need a public defender. If I
That's
could.
what I was going to appoint the public defender's office to represent you.
If that's what's needed, yes, sir. I kind of
I'll
don't
appoint the
understand.
public defender's office to represent you. I have reviewed the probable cause affidavit. There is probable cause set forth on this. So I am setting the bail amount on each of the counts at $1,000.
I was gonna say, I called the police yesterday, but they said I gave the wrong info after they wanted me to write I forgot what they called them, a statement, and I wrote the
Don't talk
statement.
about the case. I'm looking at the probable cause affidavit as far as what you've been alleged to have done.
Okay.
So I'm appointing a lawyer to represent you. The bail amount set at $1,000 per count.
Okay, I was gonna say, they told me today on first appearance, I'd be able to leave with a bail of 200.
The bail amount is set at $1,000 per count, which is, if you get a bonding company, they usually will allow you to bond out. That they'll take a premium from you for usually 10% of what the bail amount is.
Okay, yes, sir. So I will be able to do that today?
You'll get in touch with the bonding company and they will put up the bail amount.
Okay, and if I was to get the bail amount today, I'll be able to bail out today?
You can make if you get a bond for that, yes.
Okay, thank you, sir. Because I didn't understand. I the one that called the police
Okay.
and got into the incident yesterday, and I
Thank
didn't
you,
never
sir.
get. Thank you. That's it?
Yep, we've still got 2 people there.
We skipped Williams, Ezekiel.
Let's do it out there.
Williams.
Oh, Ezekiel.
Yes, sir.
Did I do that already?
No, sir.
We'll pull it up later. See if I find it here. Okay, this is Mr. Ezekiel Williams with us.
Yes, sir.
Okay, Mr. Williams, you're here charged with, okay, this is one. Do you wish to have a attorney appointed for you at this point, sir?
Yes, sir.
I'll appoint the public defender's office to represent you. Have you looked through this?
Yes, Your Honor.
Yeah, I don't know. Well, what you're charged with is improper use of a two-way communication device to commit a felony, defrauding or retaining property in excess of $20,000, grand theft, charged as a third-degree felony, and a public servant falsifying official records. This is
That one thing is less than 20,000, defining obtained property less than 20,000.
It's what now it's charged in which one, the grand theft?
The defrauding.
The defraud was for less than 20,000. Okay, I misread that. Less than 20,000. Again, it's charged as a third-degree felony. I took the time to look through all of this because it was a rather convoluted, complicated set of allegations. I have had an opportunity to look through this and actually looked up a couple of the statutes to familiarize myself with them because I hadn't seen those before. And I find that there is probable cause set forth in these allegations contained here. These are each charged as third-degree felonies. I am setting the bail amount on each one at $5,000. I'm appointing the public defender's office to represent you. Okay, sir?
Confirming there was 3 felonies.
Pardon me?
Confirming all the charges, just 3 felonies.
There's 4 felonies. The use of a two-way communication device, the defrauding to obtain property, grand theft, less than $5,000, and public servant falsifying official records.
Thank you.
Okay, thank you, sir. Okay, so somebody else, there's more people there.
That's it, South County.
Oh, that's it from the, okay, I just saw some
Thank you.
other people sitting there. Okay. Okay, now we're going to turn our attention to South County, and I guess this is Central. The Central County where we have some of our female inmates. First case we'll call up is in regard to Angela Barrerero. Ms. Barrerero, you're charged with possession of methamphetamine, possession of drug paraphernalia, and possession of a prescription drug without a proper prescription. You have a right to have a lawyer. Would you like to have a lawyer appointed, ma'am?
Yes.
I'll appoint the public defender's office to represent you. I have had an opportunity to review the probable cause affidavit. And it appears that she was a passenger in this car, in this purse. I'm going to find that there is probable cause for these charges. I am setting your bail amount on count 3. I'm sorry, the F3, the count 1, possession of methamphetamine at $5,000, on the possession of prescription without a proper prescription at $250, and the possession of drug paraphernalia at $1,000.
It looks like she's on active.
She's on active probation.
Yes, sir. So she.
There's an indication on the record that she's also on active probation in 25 CF 2060 and 25 CF 7852.
State requested in standard warrant, Judge.
What we'll do at this point, I'm setting the bail amounts as I have announced them, but in light of the fact that you're on probation, I'm going to hold you on a no bond basis on each of those 2 felony cases so that they can be, your attorney can look through this and see if there's an opportunity to get bail set or something done with the probation. But since you're on probation and new law offenses would constitute a violation of probation, I'm going to hold you on a no bond basis in both of those earlier cases.
I would ask the defender to be appointed on the 2
I will,
violations.
thank you. I'm appointing the public defender's office, not only in the most recent case you're facing, but in also those 2 earlier cases. Did you have a lawyer in the 2 earlier cases?
I did. I don't know if I'll still have them though or not.
Is that a private attorney?
I did, but I'm not sure if I'll be able to hire them again.
Okay, that's fine. I'll appoint the public defender's office. If you decide you want to hire your own lawyer, you'll be given that opportunity, ma'am.
All right, thank you.
Yes, ma'am. Next case we'll call up is Laura Bowling. And Ms. Bowling is there. Ms. Bowling, you're here charged with possession of drug paraphernalia, possession of methamphetamine. You have a right to have a lawyer. Would you like to have a lawyer appointed?
Yes, sir.
Appoint the public defender's office to represent you. I have had an opportunity to review the probable cause statement dealing with what was found, and there is probable cause. I am setting your bail amount at $5,000 on the possession of methamphetamine and $1,000 on the possession of drug paraphernalia. Thank you, ma'am. Next case we'll call up is Alexandria Calderon. And Ms. Calderon, you are here as a result of a warrant having been issued out of the state of New Jersey. There's an indication that there's an active warrant out of Bergen County, New Jersey. And it says that you're also already incarcerated on another charge. So this is something they found while you've been in custody, apparently. Did you have a lawyer appointed in the other case?
I had a public defender.
You've got a very good lawyer then. I will appoint the public defender's office just so that they can review this on your behalf also. I don't see on here what it says about any bail amount. Do you see anything? Let's see. Okay, there's no indication as to whether or not New Jersey that the warrant says anything about the bond. So that will be dictated by whatever the warrant issued might say. But I'm appointing the public defender's office to represent you on this fugitive warrant out of New Jersey.
Okay.
Thank you, ma'am.
Thank you.
Next, we'll call up in regard to, it looks like this here is Karen Deason. I don't know.
It's here, Densson.
Hmm?
It's Densson. Yes, sir.
Densson. I don't really know what I did with that. I don't.
I have it pulled up on screen for you. It's a warrant out of another jurisdiction.
Okay. Miss, and it's pronounced Densson? Kira
Yes, sir.
Densson? Is it Kira? Is that the way it's pronounced, Kira?
Kiera.
Kiera Densson is with us. Ms. Densson, there's an active warrant indicating that they're going to seek your extradition to over to, well, it's out of Seminole County. So basically you're here and do you have any charges pending here?
No, sir.
Okay, so I thought, I remember reading this one because I remember there's two of them. There's out of Sumter and Seminole. So what we're going to do is notify both Sumter County and Seminole County, and they'll get to argue between themselves as to who gets you first. And you'll be held and taken in front of Judge Harb. Here, it'll be Judge Harb. Just here, okay, it'll be brought back to first appearance here if you're not picked up and taken as has been ordered there.
Thank you.
Yes, ma'am. So next case we'll call up is in regard to Karen Ellison. Ms. Ellison is present, and Ms. Ellison, you're here on an information having been filed and an arrest warrant or capias being issued for your arrest. You're here on a fraudulent use of personal identification, bail set at $5,000, defrauding, obtaining property in excess of or less than $20,000, $5,000 bail amount. Fraudulent use of a credit card is set at $5,000. Possession, receiving, retaining stolen credit card or debit card, $5,000, and felony petty theft set at $5,000. I'm honoring those amounts that have been previously set by the judge issuing this habeas. You have a right to have a lawyer. Would you like to have a lawyer appointed, ma'am?
Please.
I will appoint the public defender's office to represent you on this.
Thank you.
Yes, ma'am. Next, we'll call up in regard to, it looks like Morgan Candle.
Yes.
Ms. Candle, good afternoon. You're here on an alleged violation of probation. The judge issuing this arrest warrant indicates you to be held without bond and taken in front of them. So whichever judge this is assigned to, you'll be taken in front of that judge. You were on probation. Did you have a lawyer in your earlier case?
No.
Would you like to have a lawyer appointed at this point?
Yes.
I will appoint the public defender's office to represent you, ma'am.
Okay, thank you.
Yes, ma'am. Okay, next we'll call up in regard to, it looks like, I don't, okay. Is it Amelia Martinez? We did that one already. The next one's Kiana Mina or Mina?
Mina.
How do you pronounce it?
Mina.
Okay. Okay. You're here on a warrant that was issued by Judge Harb, indicating an alleged violation of probation. He's indicated also on this or that you're to be held on a no bond basis to appear in front of him. Did you have a lawyer in the earlier case?
No.
Would you like to have a lawyer appointed now?
Yes.
I'll appoint the public defender's office to represent you, ma'am.
Thank you.
Yes, ma'am. Next case we'll call up is in regard to Gianna Ortiz. Ms.
Yes, sir.
Ortiz, you are here as a result of a failure to appear for arraignment. And habeas was issued, and there's two separate instances. Failure to appear for arraignment on a charge of driving without suspended license and no vehicle registration. The bail amount or bond amount has been set at $1,000 on each of those two counts by the issuing judge. Would you like to have a lawyer appointed?
No, sir. I'm just a bit confused as to regarding my charges. I was advised, like, when I was arrested that, it was for failure. I'm sorry?
Let me just explain. It's a matter that, what I have is the two warrants or habeas that have been issued saying that you failed to appear for whatever arraignment. On these two separate cases.
Yeah, so like the circumstances, right? They had
No,
stated.
I don't need to know the circumstances because I can't do anything with the warrant that's been issued other than make you aware of why you were here and follow up with what their bond amount is set at. It'd be up to that judge having this order issued to take care of this. So I'll appoint the public defender's office to represent you. You can discuss the circumstances with that public defender and that they can file a motion to either reduce those bail amounts, but you can bail out or bond out for the $1,000 on each of the two cases, ma'am.
Okay.
Okay.
I would like to be appointed a lawyer then.
You'd like to what?
I would like to be appointed a public defender.
I'm appointing the public defender's office to represent you.
Thank you.
Yes, ma'am. Next case we'll call up is Kira Rivers. She's coming back tomorrow. Okay. Next case I'll call up then is in regard to Jennifer Scarpetti.
Yes, Your Honor. Office just want to be heard regarding court date.
Okay, this is another warrant issued by Judge Harb and indicates a no bond hold, very much like the earlier one.
Yes, and again, it's financial only. So I would just ask for an earlier court date.
Okay, well, I'll appoint the public defender's office and we'll schedule this for next Tuesday in conjunction with the other one. So again, what's going to happen is your attorney's going to have an opportunity to have whatever lawyer from the public defender's office appear in front of Judge Harb to see about either reducing this or getting a bail amount set. Okay, ma'am?
Thank you, Your Honor.
Yes, ma'am. Next, we'll call up Tracy Screws. Ms. Cruz, you're here on an alleged violation of probation. Look through this again. And there's a warrantless arrest by the law enforcement at the request of the probation officer. And let me just take a look at this. This is what she was on probation for. Probably related. Okay, I'm going to order at this point, in light of this being a violation of probation, that this will be a no bond hold until you can appear in front of Judge Harb. Would you like to have a lawyer appointed, ma'am?
Yes.
I'll appoint the public defender's office to represent you on this alleged violation of probation.
All right, thank you.
Yeah. Next, we'll call up in regard to have a
Yes.
Wanda Shanks.
Shanks, Your Honor.
Yes, looks like Shawanda Shanks.
Yes, sir. It's Shantae Shanks.
Trying to see if I saw that. Okay, could you stroll down a little bit? This is an alleged battery on a person while you're detained in custody. See, okay, in any event, it's been alleged that you've were involved in some type of altercation, you battery on a person that is in the jail. What is this charge compared to that? See, 3rd-degree felony, battery on a detained person. You have a right to have a lawyer. Would you like to have a lawyer appointed?
Sir, it was self-defense.
Well, that's not for me to decide today. That's what I have here is the allegations which establish probable cause for it. So it's a matter of that being brought up in front of a judge and or letting your lawyer talk about that, argue that. I'm going to find that there is probable cause and we'll set your bail amount on this charge at $5,000. I'll appoint the public defender's office to represent you.
Thank you.
Yes, ma'am. That was. Okay, next is Evelyn Soto. Ms. Soto, you're here charged with operating a motor vehicle without a valid driver's license as a 3rd or subsequent offense. And would you like to have a lawyer appointed?
Yes.
Okay, looking through this, there is probable cause. I am appointing the public defender's office to represent you and will set the bail amount at $1,000. Okay, next we have Kamika Venerable.
Yes.
Good afternoon. I have in front of me here that you were arrested on a warrant that apparently is issued out of Orange County. There is a warrant that's been issued and on it, it indicates that there is a no bond hold. So you're going to be held without bond and taken, we'll make Orange County aware of your immediate availability and they'll make arrangements to come get you. If they don't come get you, you'll be brought back in front of a judge by next week.
Okay.
Okay?
Yeah.
Thank you. Okay, next we have Donna Windsor. She bonded.
Yeah.
Okay, so Donna Windsor's not there, is that correct? Okay. I had to, for both of your sake, did you read this one?
Oh, yes, one, sir.
Yes.
Donna
I
Windsor.
I had to look that
yes.
statute up
I
also.
never heard of that.
I hadn't either.
I had to look it up.
I did. I was gonna have probable cause challenge on that if you wanted.
I mean, I had to look that one up. I had no idea.
Although I must say, I'm glad that statute exists.
Yeah, but I didn't realize it was a 3rd-degree felony. It just, okay, just interesting. I digress, I'm sorry. Next case we'll call up is in regard to Sharon Young.
Yes.
Young, good afternoon. Let me find out. Looking through this, it appears that you're here charged with driving while your license was suspended or revoked, and also a DUI with the blood alcohol content of 0.15 or higher. And let me just ask, the affidavit shows a charge of the DUI and DUI with 0.15 or higher. Is that separately charged?
Yes, so when there are different levels of DUI, they are charged as separate case numbers. Typically, those, if there's a repetition, that's dealt with later in the process. So there won't be sentencing on them. But as far as probable cause, my understanding is that's done so that those charges are maintained through the clerk system and through the process.
It just
But that is
to me to ultimately probably be double jeopardy, but.
Yes, Your Honor, they've been doing that for a while now, but I would ask for obviously a lower bond or ROR on the extra DUI charge.
Okay, I mean, since they do coincide with the same alcohol, what I'm going to, I do look into, well, first of all, would you like to have a lawyer appointed?
Yes, please.
Public Defender's Office to represent you. I'm setting the bail amount on the charge of the alcohol, what is it called again? The DUI with blood alcohol of 0.15 or higher. I'm setting the bail amount at that at $1,000, and I will, on the possession of or the DUI otherwise charged as an M2, do that an ROR, and on the knowingly driving and suspended license, the bail amount will be at $250.
Okay. Thank you.
It's on each of the counts, but I think that while they're charged separately, I had a question. They're two separate charges, but ultimately arising out of the same DUI.
And she's on probation in Volusia County.
Oh, yeah, and she's on probation, but that's not the charge here.
No, sir.
Okay.
It's just something that we find that's open, so.
Yeah, and you need to understand, if you're on probation for anything, you should get in touch with the probation officer once you get out and let them know what's going on. It's better that they hear from you than figure it out some other way.
Understood.
Okay. Does that take care of the females for us? Okay. Okay, we'll turn to our gentleman at this point. And the first case we'll call up is in regard to Michael Ackerman.
Senator Senator's office, I'm going to have a call about challenge on this case.
Probable cause count. Okay. And Mr. Ackerman is there. Let me look down through this. Okay. He's charged with a violation of injunction against stalking.
It's my neighbors, sir.
Oh, I've read the probable cause affidavit. Don't discuss what's going on in the case.
I apologize.
That's okay. I know the inclination is to want to say something, but again, this is recorded and can be used against you later, so it's best not to say anything. I will appoint the Public Defender's Office to represent you. And what is the probable cause question?
The incident occurred on May 19th, but in the first paragraph, it says that the injunction expired on April 17th, 2026. So if it expired, then how can he violate it a month later? So that's my probable cause challenge, that if it's not in effect, that he can't be charged with it.
You see that in the?
Yes, sir, but I also see that the case number that's attached to that is a 2026 case number. So I suspect it's a typographical error, though I don't know for sure. I'd request 24 hours to perfect, as I expect we can get to the bottom of that.
Looking at that,
I can.
What I'm going to do is, based on the allegations contained in this probable cause affidavit, find that there is no probable cause, because as has been pointed out by the attorney, that the allegation is that this occurred on May 19. Let me just confirm that by looking, yeah, and that's contained on the front side of the affidavit too. And that it has an expiration date on the injunction of April of 2026, so that injunction would not have been in place, and it's alleged as a violation of injunction. So based on that, I'm going to find that there's no probable cause. And Mr. Ackerman, I would just encourage you, no matter what the dispute is between you and a neighbor.
Yes,
that
sir.
I'm not ordering, I can't do that, but I would just encourage you.
I'm
Not
gonna just
that,
let you know, I'm gonna go Calla. I'm gonna sell my house. I'm done with it, sir. So this.
that's fine,
it's
I'm
done.
just saying, I'm just encourage you to avoid him and don't allow anything to escalate.
I understand that. Thank you, sir.
For the United States request for 24 hours.
Yes, I'm going to do
Yes.
the state's request because I think it's on its face. I mean, you can somehow refile or do whatever if you need.
Yes, sir.
So he would be ROR.
It'll be ROR, but it's not even ROR. It's going to be released because there's no probable cause.
Yes, thank you.
Mhm.
Thank you very much, Your Honor.
I'm finding no probable cause. That's the only trouble. Okay, next we'll call up is in regard to Carlos Andihar.
Henderson with the defender's office. We were pointing on his case yesterday. This is another bring back for probable cause challenge. I was challenging the robbery charge. I did get another report from the state, a new and improved report. However, even with the new report, I still have a probable cause challenge on the actual robbery part of the charge. Yesterday, we didn't even have any allegations as to whether he said anything to her. Of course, this affidavit, she claims that he said he was gonna kill her or something to that effect. But for the robbery charge, obviously he didn't even come around her close enough to touch her or anything. So he didn't take anything from her person. The question, I guess, arises whether or not the beer or the drink or whatever that he took is in the custody of her. But I still think this is a long stretch for a robbery charge. When I believe the beer was in a cooler, and where he went to get the beer. So I think I understand the petty theft charge. I still don't see that there's adequate probable cause for a robbery based on the alleged facts in the affidavit.
What says the state?
And can I get the last name again, Judge?
Pardon me?
Can I get the last name again, please?
The last name is Andihar.
Oh, thank you, thank you. Yes, sir. Well, there is an amended affidavit in referring to 812.13 robbery. I'm just reading the definition. In part, means the taking of property which may be the subject of larceny from the person or custody of another with the intent to deprive them of it. When in the course of taking, there is a use of force, violence, assault, or putting in fear. And I think the allegations in this case are that the store clerk is in charge of the store, that the property therein was within the store clerk's custody, that the allegation was made of a threat of use of force, and there is an explicit statement that the clerk was put in fear because of the actions or statements of the defendant. So with regards to probable cause, the state's position is that the elements are met by the allegations therein, and for the purposes of probable cause, that the court has what it needs to find probable cause. As far as the risk to the community or how much property was taken, I don't think that goes to the elements of robbery themselves. I think that was taken care of with the petty theft. Thank you.
Yes, any response?
I would just point out that they watched the video of him standing at the front counter. Then he turns and goes to the rear of the store and walks out the front door holding a silver and color object. So that's when he got the beer or the drink. But I know it says custody of another, but it wasn't even, close to her or anything. I just think this is a stretch for a robbery charge.
I agree. It's probably a real stretch, but I think that the threatening physical harm allegation and taking something for which she's responsible at that store suffices at this point. So I'm going to I understand what you're saying, but I will set the bail amount on this, on the robbery without a firearm or weapon. I'll do it just at $10,000 on a second-degree felony, the petty theft at $250, appointing the public defender's office to represent him.
Thank you.
Okay. It was a good argument. I mean,
Well, it's for probable cause, not charging, so we'll,
I know.
there may be, well,
it'll be,
yeah.
I mean, let's just.
But there's more to do on this case from the state's point of view,
I
of course, Judge.
appreciate that. Yeah. It's $10,000 on that too. Thank you, sir. Next case we'll call up is in regard to Luis Arrojo Alvarez. Sir, you're here charged with reckless driving.
Yes, sir.
It's just a reckless driving, right? Reckless driving. And that is a second-degree misdemeanor? Is that a second degree?
Oh, I apologize, Judge.
Reckless driving?
My recollection was first, but if I may,
Sure.
may have just a moment, I want to be sure I tell the court correctly.
Lane finish, reckless driving.
See this going to.
316.
What? Yes, sir. According to 316-192, on a first conviction, imprisonment not more than 90 days or fine of not less than $25 or more than $500. So it's punishable by more than 60 days, but it is less than the 364. So
So I don't know if it's charged as a, I'm going to treat it as a second degree.
Yes, sir.
And I'm going to set the bail amount at $250. Would you like to have a lawyer appointed, sir?
Yes, sir.
Appoint the public defender's office to represent you. Your bail is set at $250, sir.
State will ask to be heard with regard
Thank you.
to.
Open case?
Yes.
What's the open case?
6 mm 288.
What's the charge?
Possession of cannabis, possession of drug paraphernalia.
So he has an open case. It's not on probation, it's just an open case. So what is this? This is reckless driving. I'm going to leave this at the bail amount, and if the state wants to file a motion for Parker on him, that will be separate and apart. So do you, Mr. Arrojo Alvarez, do you have a lawyer in your other case that's pending?
A public defender?
So you've got a lawyer. I would immediately tomorrow call, if you make bail, call that public defender and let him know what's happening.
Yes, sir.
We have a representative from the public defender's office here, and she has a lot on her plate right now. But she will, you just need to get in touch with the lawyer that's representing. I'm pointing the public defender's office on this, but you've got this other matter pending, so you might just anticipate something occurring along those lines. It's better for you to reach out to your public defender, let them know what's happening, rather than they find out some other way.
Yes, sir.
Right.
Thank you.
Yes, sir. Just don't do anything stupid while you're out, huh? Okay, next case we'll call up is in regard to Edric Bennett. And Mr. Bennett, you're here alleged to have committed a domestic violence battery and a domestic violence or violent battery by strangulation. Do you have a right to have a lawyer? Would you like to have a lawyer represent you?
Yes.
I will appoint the public defender's office to represent you. I am at this point looking at the probable cause affidavit, there is probable cause in regard to count one, or at least just the domestic battery is setting the bail amount at $1,000 on the third degree felony, the battery by strangulation at $5,000. And I am also going to order that be as a condition of probation with the conditions 8, 9, 10, 11, 12, which I've earlier described in force. Also, condition 16, not possessing or carrying any type of firearm or weapon. 17, you're prohibited from having any contact with the alleged victim. No contact means that. No cards, no letters, no telephone calls, no texting, tweeting, emailing, or trying to get in touch with her through any third person. It appears that this was a residence that you both lived in together. You'll have an opportunity within 48 hours of your release to contact law enforcement and be accompanied by law enforcement to pick up any personal effects. This order remains in place until otherwise modified by a judge. So no contact, no telephone calls, no going anywhere where this person could possibly be. And that will be okay. So I'm appointing the public defender's office and setting that bail.
Yeah, apologies. You gave him the one time to go back.
Yeah, I did, that he can go within 48 hours in the company of law enforcement. What you do is you contact law enforcement, make arrangements, and they'll accompany you to get any personal items that you need to get.
Your Honor, I had called the police and I don't want to file charges, but they brought me to jail.
You can talk to your lawyer about that at this point. That is in place. Okay, next case we'll call up. And it will call up Charles Birdsong.
He bonded out.
Bonded. Okay. Okay, next case we'll call up then is Patril Bland.
Yes, sir.
Bland. Mr.
Yes, Your Honor.
You were here charged with, let's see, driving while your license suspended or revoked as an habitual offender. I've had an opportunity to review the
Justin.
probable cause affidavit. Would you like to have a lawyer appointed, sir?
Yes, Your Honor.
Appoint the public defender's office for you provisionally. There is probable cause in light of the number of problems here. I'm going to, or the bail amount is set at $5,000.
Thank you, Your Honor.
Okay. Next, we'll call up in regard to this is next. We'll call up in regard to Justin Chalker. And Mr. Chalker, good afternoon. You're here charged with resisting an officer without violence, misuse of the 911 system, possession of methamphetamine, possession of drug paraphernalia. You have a right to have a lawyer. Would you like to have a lawyer appointed, sir?
Yes, sir.
The public defender's office to represent you at this point. Read the probable cause affidavit, going back through my notes on it here. And there is probable cause for these charges. I am setting your bail amount at $1,000 on the resisting without violence, $1,000 on misuse of the 911 system, $5,000 in possession of methamphetamine, and $1,000 on the possession of drug paraphernalia. And you may, again, bail out for those amounts. Okay. Thank you, sir. Next, we'll call up Joseph Collier. Good afternoon, Mr. Collier. Mr. Collier, you're here charged with possession of drug paraphernalia, possession of cannabis, and possession of methamphetamine. I'd like to have a lawyer. Would you like to have a lawyer appointed, sir?
Yes, sir.
This office to represent you. I am looking at the probable cause statement, which I had an opportunity to look over earlier. There is probable cause for these various charges. The bail amount is set at $1,000 in the possession of cannabis, $1,000 in the possession of drug paraphernalia, and $5,000 on the possession of methamphetamine, sir.
Thank you, sir.
You. And next we'll call up in regard to Taylor Evans. Taylor Evans. Good afternoon, sir. Sir,
How you
you're
doing,
in
Judge?
charge of domestic violence battery and with criminal mischief. Let me look back and through this, the criminal mischief deals with the phone. You have a right to have a lawyer. Would you like to have a lawyer appointed, sir?
No, sir.
Hire your own?
No, sir.
Okay. Well, your bail amount is set on the criminal mischief at $5,000. On the domestic violence battery, let me look at this for a second. Domestic violence battery, I am setting the bail amount at $1,000 as a condition of pretrial release. She contacted her.
I have no priors of those.
Pardon me?
Said I don't think I have any priors of those charges, Your Honor.
Well, that's one of the things you can deal with. If I'm looking at the probable cause affidavit that sets forth sufficient grounds to have these charges, what comes of them will be dependent on what goes on in further proceedings. But I am finding there is probable cause. There is the $5,000 on the criminal mischief charge, $1,000 on the alleged domestic violence battery. That is a condition of pretrial release. There'll be conditions 8, 9, 10, 11, and 12, which are the standard conditions. Condition 16, not possess or carry any type of firearm, gun, or weapon. You're also at this point prohibited from having any intentional contact with the alleged victim until further order of the court. No contact means just that, no cards, no letters, no telephone calls, no emails, no texting, no going anywhere near where she is going to be. You have a right to go in the company of law enforcement within 48 hours of your release to obtain any personal effects, personal property, medications, things like that. But that will have to be in the context of having a law enforcement officer. This is all subject to change. Your attorney, once they get involved in it, can file a motion to modify that. So,
Yes, sir.
okay, thank you. Next case we'll call up is in regard to Jordan Green. Mr. Green, you were here alleged to have committed a domestic violence assault on somebody 65 years or older. And it appears that you resided in the same household. Would you like to have a lawyer appointed, sir?
Yes, sir.
Appoint the public defender's office to represent you. The nature of this is charged as an F2 because of the age. I'm going to take a look here. Set the bail amount at $10,000 as a condition of pretrial release. Again, conditions 8, 9, 10, 11, and 12 are standard conditions which will be imposed. along with condition 16, no possession, carry of a firearm, gun, weapon, or ammunition or knives. You're also prohibited from having any contact with this alleged victim. No contact just means that. No cards, no letters, no telephone calls, no emails, no going any place where that person is a reasonable expectation of being. It appears that you lived in the same house. You'll have an opportunity to go there in the company of law enforcement to pick up personal effects such as clothing and or medications, and otherwise no contact. That can be modified by a motion at a further date by your attorney. Again, I'm appointing the public defender's office to represent you on this, sir.
Thank you.
Yes, sir. Thank you. Next, we'll call up in regard to Shane Thomas Holder.
Yes, sir.
The Holder.
Yes, sir.
You're on an alleged battery. And would you like to have a lawyer appointed, sir?
Yes, sir.
I'll appoint the public defender's office to represent you. Looking through this, there is probable cause supporting the allegations. I'm setting your bail amount on this at $1,000, but more importantly, it's going to be as a condition of pretrial release that you report to pretrial release 2 times a week. On this one, just make 1 time a week. Yeah, 1 time a week that you report to pretrial services. There'll also be condition 16, no possession of any firearm, gun, weapon, ammunition, or knives. That you're prohibited from having any intentional contact with the victim, meaning no cards, no letters, no telephone calls, no emails, no texting, or attempting to contact her through any third person until further order of the court. No going anywhere within 500 feet of where you have a reasonable expectation of her being. Also, it does not appear that you lived in the same home.
No, sir.
Okay, so just stay away until further order of the court, for this is taken care of. Okay, sir?
Okay, thank you.
Yes, sir. Next case we'll call up is in regard to Avery Johnson. He bonded. Avery Johnson's bonded. Okay. Next case we'll call up then is in regard to Devontae Johnson.
How you doing, Your Honor?
I'm doing okay. Mr. Johnson, it appears that there's an allegation that you violated terms of your probation.
Yes, sir.
And looking through this was a warrantless arrest based on a request by probation. And so
Yes,
you've
sir.
been arrested on the alleged violation of probation. Do you have the underlying cases? For those this. Okay, it looks like 20, I don't know if it's 25 CT 1970. Look at you, bring it up. Your city's been, that you're on probation in some other cases.
Yes, sir. Yes, sir.
Okay, and let me just look at this. It looks like that case is 26 CF 15169. Is that it? Okay. No, here they are. 25 CF 6567 25 CF.
Yes, 4.
CF 25 3915 CF 25 1970. Okay, so what I'm going to do is, at this point, since you're on probation and alleged to violated probation, hold you on a no bond basis at this point. And I'm appointing the public defender's office. Did you have a public defender earlier in the when you were put on probation?
Oh, yeah, yes, sir. Yes, sir. I had to pay a friend when I did 270 to get
Okay.
information.
So I'm going to appoint the public defender's office now on these alleged violations, for the alleged violation of probation. You'll be held on a no bond basis and taken in front of Judge Hart, sir.
Yes, sir. May I ask when of my next court date?
June 15th.
All right.
Thank you, sir. Next case we'll call up is in regard to, it looks like, Michael Land. Pardon me?
Land. You say Michael?
Let me call up Land since I got that right here in front of me. Okay, Mr. Land, you're charged with possession of methamphetamine, possession of drug paraphernalia. You have a right to have a lawyer. Would you like to have a lawyer appointed?
Yes, sir.
Appoint the public defender's office to represent you. Appears to be probable cause. I am setting the bail amount at $5,000 on the possession of meth and $1,000 on the possession of drug paraphernalia.
He's not on probation.
He is on probation?
No, he's on conditional release supervision. He pled to prison on June 15th of 2022. And he's still in conditional release supervision till 9/11 of this year, but that's a parole thing. That's not probation. There's a difference.
Okay, so what might happen is that if you're on parole of some sort, they might be determining what they will need to do with you in that case at this point. So if you are on parole, if you're reporting to anybody, I would strongly recommend that you get in touch with whoever you're reporting to let them know what was going on.
Yes, sir.
Okay, I'm going to go back and call up Chance Kessler. Kessler is approaching. Mr. Kessler, you have a right to have a lawyer. You're charged here with fleeing or attempting to elude a police officer. And I looked through this. You have a right to have a lawyer. Would you like to have a lawyer appointed?
Yes, sir.
Appoint the public defender's office to represent you. This appears there is probable cause here. I will set your bail amount on this at $5,000. Okay, next case we'll call up is in regard to Benjamin Langford. Mr. Langford is present, charged here with driving, not having a valid driver's license, apparently never having a license. And you have a right to have a lawyer. Would you like to have a lawyer appointed, sir?
No, sir. What,
okay.
Am I allowed to speak on, again, the issue of yesterday and my getting pulled over and being here today?
You're here for first appearance on something that is alleged to have occurred, which is today, the 20th?
Yes, sir.
Yeah, yesterday. You were arrested yesterday. So this is your first appearance.
Well, my question is, I had a bond. The officer gave me a bond right off the bat. I was very polite, very respectful. He said that he was going to do all my paperwork right there so that I was able to get a bond when I got in to get out. And
yeah, the bond amount is $250. Bail amount.
Yeah. No, I just wanted to speak on the fact that the officers wouldn't talk to me, wouldn't answer my questions, and that's why I'm here today. I should have gotten out yesterday. Well, I wanted to pay it, but they wouldn't allow me to. They wouldn't answer anything I was telling them. They were just pointing at the wall to go to talk to a computer. They weren't trying to help me in any way possible.
Okay, well, that's been noted on the record that you were dissatisfied with the way you're treated there. They should have allowed you made you aware of the fact that your bail amount was set at $250 and allowed you to bail, get in touch with the bondsman or bail out for that amount. You're right. They should have done that.
Yes, sir.
Hold you over. But in any event, your bail is set at $250. Okay, next we'll call up in regard to, looks like Tyshawn Lincoln.
How you doing today, Your Honor?
I'm doing okay. Mr. Lincoln, you're here on the alleged violation of probation. It appears that you were on probation and that the probation officer requested that you be taken into custody as a result of apparently testing positive. So you're going to be held on a no bond basis. Would you like to have a lawyer appointed, sir?
Yes, sir, but excuse me, Your Honor. I had a first appearance yesterday. I had went through all this yesterday, and they told me my court date was June 15th at 8:30. So I'm confused, Your Honor. I don't know what's going on.
I just understand. So he came on a different VOP case yesterday. He's here on his 2026 case. Yesterday, he came on the 2021 case. Unfortunately, they didn't come through the same day. So he's being violated on his newest VOP case today.
Okay, so there's two separate alleged violations. What was he held on yesterday? No bond?
Yes, it was also no bond on his.
Okay, so we're going to get these all together. It appears that there's two separate alleged violations for two separate cases. We're going to get them consolidated, put together, so they appear at one time in front of the judge, in front of Judge Hart.
So, excuse me, Your Honor, so it's still June 15th?
I think it'll still be June 15th. Yeah, we'll try to get that June 15th. Yes, sir.
Yes, sir, and my fault, Your Honor. My last question is, what is this new charge?
The new charge is an alleged violation of probation. Apparently, you were on probation in two separate cases, and they only picked up one of them when they saw you yesterday. So that there's a violation in a separate case that could all be worked out just to make sure that it's all taken care of at one time.
Yes, sir.
Okay. Thank you, sir.
Yes, sir. God bless you. Thank you, too.
Thank you, sir. Next, we'll call up Joshua Laredo.
Judge, I'd ask to be heard on this.
Sir, am I pronouncing that correctly, Laredo?
Yes, sir.
Okay, sir, you're here charged with the threat to discharge a destructive device. You have a right to have a lawyer. Would you like to have a lawyer appointed?
Yes, Your Honor.
Appoint the public defender's office to represent you, and the state indicates a wish to be heard on this.
Judge, the allegation, and there's also a domestic battery charge and a separate affidavit before the court. But with regard to the threat to discharge a destructive device, after reviewing the affidavit, it does not appear to meet the criteria under 907-041 for use of a destructive device as grounds to hold it no bond. So my review of the allegations are that he is entitled to a bond. That being said, in this count, he is facing a second-degree felony. The allegations are that he went to a particular place seeking out, as I read it, the victim of the domestic battery, and made the threats particularly at that location, at that business location. So, Judge, with regard to the F2, the state is requesting a no contact order with any Taco Bell, but also a GPS monitor just to be sure that that he complies with that requirement, and no contact with the alleged victim in the domestic battery who has at least some connection with the Taco Bell. State's not requesting house arrest at this time, just that he be tracked. Thank you.
Let me just, I don't see a separate charge for the domestic violence. I just, all the.
She didn't file it, Your Honor.
The affidavit I have is for the threat to discharge.
I have an electronic copy of that one. I can.
Oh, there is another. Okay, all I was given was the one. Let me look through that. Name shows up in the I have here.
Yes, sir.
And there's a witness. Okay, so he's facing a separate charge on the domestic violence battery.
Yes, sir.
And charged as what? Can you go ahead? Okay.
Yes, sir.
Okay, I can do that. Okay, that's charged as an M1, but you, okay. Let me just take a look at this. Okay, I am appointing the public defender. I do find that there's probable cause in the threat to discharge a destructive device. I'm setting the bail amount at $15,000 on the alleged violation.
I don't gotta do me like that.
I'm sorry, what?
Your Honor, did the motion never go through? The woman said that she was gonna drop the charges for domestic violence.
I do not see anything that's been dropped.
Okay.
Okay, so I'm setting the bail amount on the threat to discharge a destructive device at $15,000. I'm setting the bail amount at $1,000 on the alleged domestic violence battery. On each, that's as a condition of pretrial release. Pretrial release will have the conditions 8, 9, 10, 11, and 12, which are the standard conditions. Condition 16, you're not to possess, carry any type of firearm, gun, weapon, ammunition, or knives. Ammunition would include any type of explosive devices. You're not to, condition 17, you're not to go anywhere near any Taco Bell. No going onto their property of any Taco Bell, and no contact with Jasmine Diaz. No contact means, in her case, no cars, no letters, no telephone calls, no emails, no text messaging, no attempts to contact her through any third person. You're not to make any telephone calls to any Taco Bell or go into any Taco Bell property. In light of the nature and the threat here, as far as explosives, I am going to grant the state's request that we put a electronic monitor on you. It's not house arrest, but that will be an electronic monitor, so we'll know for sure that you're not going anywhere close to any Taco Bell and or Jasmine Diaz. And you're not to go anywhere close to either any Taco Bell, get within 500 feet of the Taco Bell and or Ms. Diaz until further order of the court. If there is a motion to modify that concerning her, that's something that can be heard at a later date.
Judge, that also has to be heard regarding MM 261836. That appears to be an open bond case. If the accused is charged with discharging a firearm in public, state requests that the bond be revoked and he be held Parker v. State.
Okay, that's a separate.
Yeah, the Guzman pretrial bond case, the one that Mr. Matthews just spoke of. So this would be a revoke for.
Okay, I wasn't provided that either. What I'm looking at right now is that there was a capias issued in the other underlying case to be held on a no bond basis under Parker versus State. I'll honor that. You're going to be held on a no bond basis because of the nature of the other charge. That could be separately addressed. Did you have a lawyer appointed in that case?
Yes, Your Honor.
I mean, with the public defender's office?
Yes.
Okay, so the public defender's office will be handling all these cases. Sign this one?
Yes, sir.
We could do that.
Thank you.
Okay, sir, thank you. Okay, that was Lorraine. Okay, next case we'll call up is in regard to Christopher McPherson. I skipped one. I'm sorry. Let me get Wayne Malone first. Mr. Malone is here. Charged with driving while your license is expired for more than 6 months. It's a second degree misdemeanor. Your bail amount set on this at $250. Do you wish to have a lawyer appointed?
Yeah, yes.
Okay, I will appoint the public defender's office to represent you. I'll set your bail amount at $250 on the M2.
So I do have a bill?
Wait 1 second. There's an open bond case in another case, apparently.
Yes, sir. Chargers are these here.
Okay, you're also facing some charges, possession of methamphetamine, possession of cannabis, and possession of drug paraphernalia in a separate case at this point. And it's recommended that each be a no bond hold.
Mr. Matthews.
What is this?
State request Parker hold, Your Honor.
Okay, in light of the fact that you're out facing charges and have picked up a new charge, I'm going to grant the motion for Parker hold. You'll be held on a no bond basis in the other case. And that will be, I'll appoint the public defender's office here.
And do I use the same public defender for both cases?
It might be, I don't know. I don't know if it might be two different levels of court. But they'll coordinate. They make sure they coordinate the cases, sir.
Okay.
Case number, sir? Case number for the open.
You have a
CF 262633,
Thank you.
if I may.
Okay, thank you, sir. Next case we'll call up is Christopher McPherson. Mr. McPherson, you're here on a warrant that's been issued out of Hillsborough County. And it indicates that you're to be held on a no bond basis. We'll make Hillsborough aware of your availability and they'll come get you. We'll schedule this for next week in case, just to make sure we don't lose you in the system.
All right.
So a warrant out of Hillsborough County for you. Okay, next case we'll call up is Elijah Nero.
Yes, sir.
Good afternoon. Mr. Nero, you're charged with unarmed burglary of an occupied dwelling, resisting an officer without violence, and petty theft. You have a right to have a lawyer. Would you like to have a lawyer?
Yes, sir.
With the public defender's office to represent you. Looking at this, let's just take a look here. There is probable cause looking down through this. In light of the charges here, on the unarmed burglary of an occupied dwelling, it appears that this was carport. I'm going to set the bail amount at $10,000 on the F2, $5,000 on the resisting without violence, and $250 on the petty theft. Okay, sir?
Yes, sir. What's my next court date?
What will be the next court date?
June 23rd.
June 23rd, but you'll be
Yes, sir.
interviewed by the public defender's office well before that, I'm sure.
All right, thank you.
If I may, the state's requesting an instant for warrant in CF 262219 and 25 CF 10727. In those two cases, it appears the defendant is on probation. Like one of them looks like he just got out of probationary status, maybe a month ago.
What kind of charges in those cases?
I haven't looked them up because the last entry for me was the VOPS that he just resolved. You'll bear with me for one moment.
Oh, you're good.
Right here.
Oh,
One of the, is this one too? The burglary?
It's this one here with all these charges and this one here.
That's an older case.
Those are what he's on probation for, is both of those.
Okay, so he's already facing a burglary of an unarmed. Yeah, I'm going to grant the state's motion. You're going to be held on a no bond basis on the two cases in which you're already on probation. And you'll be held no bond on both of those.
Yes, sir.
You know, I would ask for public defender to be.
And I'll appoint the public, yes, ma'am, thank you. I'll appoint the public defender's office to represent you on that.
Yes, sir.
Okay, next case we'll call up is Jorge Olivo, George Olivo.
I do have a stipulation with the state regarding one of the charges. He's charged with both resisting the officer without violence and false ID given to law enforcement. It's based on the same act. So the stipulation is that there's no probable cause and he should be released on his own recognizance on the resisting without violence charge. I also would ask to be appointed on this case. I found out later that apparently our office represents him on a case that he's on conditional release for. He's been found incompetent to proceed on October 31st of 2025. And Judge Pinkett did sign an order appointing a committee for neuropsychological testing on May 7th. So it's still ongoing, but he has been found incompetent to proceed on that and is on conditional release. I would ask, and this is not part of the stipulation with the state, but having found that out after speaking with the state about the other stipulation, I would ask for ROR on this charge based on the fact that he's incompetent to proceed on another case.
Well, first of all, I will appoint the public defender's office to represent him. This charge that you stipulated would be removed,
It'd be no bond, I mean, it'd be ROR, I'm sorry, on the resisting without violence, no probable cause on that because it's based on the same action.
okay, so no probable cause on the resisting officer without violence.
Right.
And then on the other charge, and is he out on a conditional release?
He's on conditional release on that other case.
What's the nature of the other charge?
I did not look that part up.
If you can look it up for everybody.
The state is requesting a bond, Judge.
Very good instruction. That's unable to stand trial. I'm gonna put, so he says some, it's getting, set the bail amount at $1,000, not the $5,000. Set at $1,000, just to have somebody out there working, he being responsible for. Mr. Olivo, your attorney will be answering any questions you might have, and we're gonna go ahead and address, I'm setting the bail amount at $1,000. And the other charges being dropped, sir. Thank you.
Thank you.
Next case we'll call up is in regard to James Owner. Anna?
He said he bonded.
Bonded.
Yes.
Next case we'll call up is in regard to Christopher Azura. Azura?
Orozco.
Orozco.
Yeah, and she gonna pull it out and they'll see had. See, that's. I feel like it.
Okay. There's an alleged violation of probation here. The probable cause. I didn't read this. Does appear there's probable cause. I'm going to appoint the public defender's office to represent you. You're going to be held on a no bond basis at this point.
Yes, ma'am.
The alleged violation of probation.
When will be my next court date?
June 15, sir.
Thank you, sir.
Okay. And next I have Kenny Peterson.
How you doing, Your Honor?
Doing okay. Mr. Peterson, there's been an information filed apparently.
I don't know what's going on, Your Honor. I'm confused.
Okay, well, I'll try to figure that out.
This happened way last year, man. Wow.
Okay, what I'm looking at is that there was a habeas issued for your arrest. And it says that there was a direct information filed on this, and information having been filed. And
I don't know, man.
Okay, well, a lawyer will be able to help you figure this out. I have a arrest warrant in front of me that indicates the judge has issued an arrest warrant for you, and it indicates you to be held without bond at this point. So I'm appointing the public defender's office to represent you. And it appears that this all emanates out of something that might have happened a year ago, but there's been a information filed by the state attorney's office, apparently.
I'm confused. I don't know who
Okay,
could have been.
I'm appointing the public defender's office. They'll be able to answer all those questions.
Remember, there's actually a move on until first appearance on the capias, so I would ask that he get a bond on this charge, even that.
Thank you.
Back on October 6th, allegedly of 2025.
Right, but I'm looking at, was he on probation for something?
He is on probation, active probation, and he does violate it, seeing that the KP states after he was placed on probation.
Okay, that's
okay, but I got a question, Your Honor. I've been on probation since last year. Before this, whatever's going on, and my PO just seen me Thursday. I just seen her on the 1st, and she just came to my job. And I've been on it for 10 months, and I'm about to be done with my probation, and she hasn't tell me anything or nothing. Everything she's saying, I'm doing good, and I'm confused.
Let me just say, whatever happened back in October of last year, apparently, and the state attorney is now filed an information. That means they're moving forward with it. They did whatever further investigation they wanted, and they filed an information, apparently. So the information says no bond until first appearance. The attorney I've appointed the public defender's office is seeking to have that.
How much is my bond?
That's what I'm trying to figure out.
Yes, sir. Yes, sir.
Right. What is?
Judge is charged as a second-degree felony. The state is requesting a $15,000 bond, as well as pretrial release conditions, including no contact with the named victim of the information. I would also note the allegations of the charge are that the new law violation occurred on October 6th, 2025. I'm showing that, if I've read that correctly, that
15,000?
That's not to be interrupted. I'm showing that the accused was put on probation in 24 CF 7648 on September 4th of 2025, which would predate the charges alleged new law violation.
Okay, what I'm going to do at this point, I'm not going to, if the state wishes to follow up on a alleged violation of probation, since he's been on probation for all this length of time.
I've been doing good, Your Honor.
Sir.
Yes, I'm sorry. I'm sorry, y'all.
You talk yourself out of what I'm doing here.
I'm sorry.
What I'm going to do is I'm going to set the bail amount in light of the nature of the charge at $15,000 as a condition of pretrial release. That conditions 8, 9, 10, 11, and 12 are standard conditions. Condition 16, not to possess, carry any type of firearm, gun, weapon, or other ammunition or knives. You're not to have any contact with the alleged victim. No contact means just that. No cards, no letters, no telephone calls, no emails, no text messaging, no attempts to contact her through any third person, not going anywhere within 500 feet of her home or vehicle or places of employment. I am, and in light of the probation, what I'd suggest you do is contact your probation officer so they hear from you as far as what's going on, that you've been arrested on this, and they'll make a decision as to whether or not they want to pursue any violation of probation. I think because of the time that's passed since You've been placed on probation, being on probation for this past year, and this occurring so long ago. But that doesn't preclude the state from pursuing it. That's all I'm saying. But that will be up to a different judge as to whether or not they want to attempt to violate probation on you.
So if I call my probation officer and she reinstate me or give me reinstate me, will that
Oh, this is not dealing with probation. This is dealing with the charge from last year. This is completely separate from what you're on probation.
Can I ask? Yes, sir. Can I ask what the charge was last year?
The charge was written threat to kill or injure somebody.
Man, that's crazy. People just lie on people, man.
Don't argue with me. I'm looking at the probable cause affidavit, sir.
And you said 15,000?
Yes, sir. It's a second-degree felony.
I apologize, Your Honor. I didn't hear whether the public defender was appointed or not.
I have appointed a public defender.
Yes, ma'am.
Okay, thank you, sir.
Yeah.
Next case we'll call up is Mark Petrie. Is it pronounced Petrie?
Yes, sir.
Mr. Petrie, you're here on a warrant that was issued by Judge Harb indicating an alleged violation of probation. He's indicated you to be held on a no bond basis, and you'll appear in front of him at the next Tuesday.
Petrie? Yes, it'd be June 15th.
June 15, you'll go in front of Judge Harb. Would you like to have the public defender appointed?
Yes, sir.
I'll appoint the public defender's office to represent you, sir.
All right, thank you, sir.
Okay. Next case is Brian Racine.
Yes, sir.
Mr. Racine, you're here in charge of a grand theft. You have a right to have a lawyer. Would you like to have a lawyer appointed, sir?
Yes, please.
I'll appoint the public defender's office to represent you. There is probable cause set forth in the probable cause affidavit. The rest affidavit, I am setting your bail amount at $5,000. And let me just look through this.
Thank you, Your Honor.
Okay, I don't think there will be any conditions. Yes.
Yes.
Judge, I'll ask respectfully for the court to consider issuing an instantial warrant in CF 25-5044, in which the defendant is on probation for felony petty theft and dealing in stolen
Is that
property.
Mr. Rancine still with us?
Yes, sir, I am.
You apparently were on probation when this occurred.
Yes, sir.
At this point, I'm going to order you be held on a no bond basis on the fact of a violation of probation by picking up these new law offenses. I'll appoint the public defender's office to represent you on that also, sir.
Thank you, sir. When is my court date? When's the court date?
I don't know exactly which pace now will be the train leading the leading the train.
No problem.
What
Thank
you
you.
answer that. Next case we'll call up is in regard to Jeffrey Ramirez. Bonded? Bonded. Okay, next case we'll call up then is in regard to Mark Rash.
But he was at South County, Your Honor.
Well, I already did that one. It's in the wrong pile. Okay, next case we'll call up is in regard to Edgar Edgar, how do you pronounce that?
Rebelosa, sir.
Edgar Rubilis?
Yeah, Rebelosa, yes, sir.
Okay, could you pull that one up? I can't find that.
I have it pulled up.
Hmm?
I have it pulled up.
Okay, you're here alleged on an arrest warrant that's been issued. And Judge Butts, okay, the bail amount's been set. No, but bond until, okay, you're charged with false imprisonment, tampering with the witness, and domestic battery. And what are the conditions that she, well, I can be this, can I?
Yes.
Okay. Yeah, I'm setting the bail amount on the false imprisonment at $5,000, tampering with the witness at $5,000, and the domestic battery at $1,000. That is as a condition of probation, condition of release, that you're not to possess, carry, or have any type of firearm, weapon. The standard conditions of 8, 9, 10, 11, and 12 are in place. Condition 16, again, no possession of firearm, gun, weapons, or ammunition. Condition 17, no contact. No contact means no cards, no letters, no telephone calls, no emails, no going attempts to contact this person through any third person, not going within 500 feet of the victim's home, vehicle, place of employment. And
That was the only ones.
so
It was just 16 and
in the
17.
same place. I didn't see you.
Sorry.
I was wondering, was her address is compared to
Just go down. Let's see. Just ask them if they live in the same residence.
Okay. Yes, apparently you're living in the same residence. As a result of that, you may go in the company of law enforcement to pick up any of your personal effects. Within 48 hours of your release, you have to contact law enforcement and make arrangements to go there.
Was public defender appointed as
I
well?
will appoint you want the public defender, as I recall, correct?
No, sir.
No, you're gonna hire your own lawyer?
No, sir.
You're not gonna hire a lawyer at all?
No, sir.
You don't want one appointed?
No, sir.
Okay, well, you're gonna be in custody unless you can make that bail with those conditions, sir.
Okay, Your Honor.
Okay, thank you. And then we have it's Danique.
Yes, sir.
Pronounce your last name, Rosius?
Yes, sir, Rosius.
Okay, Mr. Rosius, you're here charged with domestic violence battery, a simple battery, and resisting an officer without violence. Look down. You have a right to have a lawyer. Would you like to have a lawyer appointed?
Yes, sir.
And I'm looking down through this.
I said no, but can you clarify?
I apologize, I can't hear whether he said yes or no.
You said you wanted a
Yes,
lawyer.
sir.
You want a lawyer, correct?
Yes, sir.
I'm going to appoint the public defender's office to represent you. I was looking through the probable cause affidavit as far as what gives rise to all this. And the only real question I have looking at this appears to be as a result of what people were told by the two children. I don't think there was anybody that actually witnessed the event, but they witnessed the alleged consequences of the event.
Victims, the children were the named victims and they reported to the adults that were named.
Correct, I know. I mean, but it was, in essence, nobody witnessed what purportedly. I just throw that out. It just caused me, let me just say, it just caused me to sit back and look at it thoroughly. I think there's sufficient amount of evidence here to allege probable cause. And at least that the resisting officer with him being there investigating what was happening. So I'm going to appoint the public defender. I'm setting the bail amount on each of the 3 misdemeanors at $1,000. And it will be as a condition of no contact with these minor children. No contact means you can't go anywhere close to those kids at this point. And so those children are, what are their names?
I think we typically refer to them by initials, Judge.
Pardon me?
In open court on the record, I think we typically refer to them by initials.
Well, just, there'll be no contact to the with the minor children. No contact means not going anywhere close to where those two minor children might be, to their house for sure. That's the standard conditions of 8, 9, 10, 11, and 12, along with no possession of a firearm, gun, ammunition, or knives, and no contact with those alleged minor children, sir. I am appointing the public defender to represent you.
I believe they all live in the same residence.
Pardon me?
I think they all live at the same house.
I don't know. It's
It was my residence.
The same
One
one.
did, one didn't.
okay, so you will be able to go to that residence and in the company of law enforcement to pick up any personal effects. And that will be within 48 hours of your release. You contact law enforcement to schedule somebody to accompany you to the house to pick up your personal effects. Okay, next case I'll call up.
Is that pretrial release?
It's pretrial, condition of pretrial release with the bail amounts that I said. Okay, we already did Shanks, right?
Yeah, it's on the council.
Okay, next we'll call up regard to Corey Shayland.
Yes, sir.
Shayland, you're here charged with possession of drug paraphernalia and possession of cannabis.
Sean Margaret.
Yes, sir. I got a question, Your Honor. I'm trying to figure out how can I be charged with those charges when I have a registry card. I'm registered. And my marijuana was never out. I had just left out.
What is alleged here is that the marijuana was allegedly found in a clear plastic bag, was arrested because it was not in wasn't in a proper container, purportedly. But you're also, apparently you're on probation for an armed robbery.
No, sir.
So
I'm on probation, but not for an armed robbery.
Pressing those two as well.
Armed burglar, I'm sorry.
Now, these charges are over 10 and a half years old.
He's here for a violation of probation as well, too.
Okay, it's violation of probation by picking up the new law offense. Yeah. And regarding it said that you advised that you had the valid medical marijuana card that was arrested and charged in possession.
I never had no marijuana out, Your Honor. That's what I'm saying. I never had no marijuana in no other type of bag. My marijuana wasn't out. I just left out of the plasma place.
That's something you can, all I'm saying is that the advice that it's illegal to have cannabis not in its original container.
It was never in this, you know what I'm saying? It was never out of its
Argue
original.
with me. I'm just looking, you're on probation. I'm violating your probation anyway for new law offense. So you're going to be held on a no bond basis on the alleged violation of probation. If it turns out that this was not something that you should have been arrested for, that can be taken care of by the judge in the probation court. But it alleges here that that it was not in the proper container, which I don't know if there's supposed to be a proper container. What is the state's position?
Yeah, it's I have a pouch like whenever I go to.
I'm talking to the state right now.
State's position is the court stated the law correctly.
Okay, that it's supposed to be in whatever the container is that you obtained pursuant to the use of your medical marijuana card. and it's alleged that it was not in that type of container. So I am finding this probable cause. I am setting the bail amount on each at $1,000. But since you're on probation, I am at this point ordering that you be held on a no bond basis. I'm appointing the public defender's office to represent you, and you can discuss this further with your lawyer and then with the judge in the probation.
When is the court date?
That'll be next.
He's got two. So the arraignments for the new charges are June 5th and at 8:30, and then his VOP set for June 15th.
The VOP will be set for June 15. You've got an arraignment on this on June 5 on the new charges, and that you could bring this up with your lawyer then, and they can discuss it with the judge to whom this is assigned at that point too.
So there's no way I can take care of them two charges today?
Not today, no, sir.
Okay.
Okay. Let's find that. That was. Okay, next case I'll call up is in regard to Mark Shell.
Yes, sir.
Good afternoon. Mr. Shell, you're here charged with false imprisonment, domestic violence, battery with strangulation, and domestic violence. And let me just look down through the probable cause affidavit again. And would you like to have a lawyer appointed for you?
Yes, sir.
With the public defender's office to represent you. And
then, excuse me, Your Honor, I have a question if you don't mind.
go ahead and ask the question. Don't discuss the case.
I was told by the officers that it was allegedly and that everything was under investigations. I have no priors or anything, no criminal history. I don't even get in trouble. This is something new to me. I've never been in jail in my life. And I'm just trying to see if it's under investigations and I allegedly did those things or whatever the case may be. Why am I being charged with it if it's in investigation? That's what I was told.
That's what the investigation, the probable cause affidavit, which is an affidavit provided to me. It's an arrest affidavit from law enforcement. They go through what is alleged here. And my job is to determine if what they allege, if it's facially sufficient to support the charges, then they can move forward with them, even though they might still be investigating. That's going to be also something the state attorney's office gets involved in further investigation. But the allegations here are sufficient to support the charges. You have a right to have a lawyer. Would you like to have a lawyer appointed?
Yes, sir.
I'll appoint the public defender's office to represent you. I'm just trying to see, it seems again, are they two separate charges of the strangulation and the domestic violence?
I'm just trying to see how I got that and I never did that.
Well, that becomes a question that have to be figured out later. The allegations here are sufficient. I'm going to.
I think there's a punch to the face as well, Judge.
Pardon me?
There's a punch to the face as well.
Yeah. I'll set the bail amount on the false imprisonment aspect of it at $5,000, on the domestic violence with strangulation at $5,000, and the simple domestic violence at $1,000. All of those are as condition of pretrial release. Conditions 8, 9, 10, 11, and 12 are standard, which I earlier went over. I am also imposing 16, not to possess, carry any type of firearm, gun, weapon, or ammunition. You're prohibited from having any intentional contact with the victim. It means no cards, no letters, no telephone calls, no emails, no text messaging, no attempts to contact her through any third person. And again, appointing the public defender's office to represent you.
Yes, sir. And then if you don't mind, Your Honor, can you tell me how much in total is my bond?
Your total bond is what, $11,000?
11,000.
Yes,
Okay.
sir.
Yes, sir. Thank you.
Yes, sir. Next case we'll call up is in regard to Perry Taylor.
Yes,
Perry
sir.
Taylor. And you were here on a warrant issued for an alleged violation of probation issued by Judge Harb. On a no bond basis, you'll be held and taken in front of Judge Harb to answer to the alleged violations of probation, sir. I'll appoint the public defender's office to represent.
Sir, is there kind of way we can resolve this? Cause I'm not going back out on probation. I just want to do the time and be through with it.
You can discuss that with Judge Harb.
Okay. Okay then. All right then. All right,
But
thank you.
I'm appointing a lawyer to represent you. The next case we'll call up is in regard to Alexander Tillman.
Good afternoon, Your Honor.
Mr. Tillman, you're here charged with domestic violence battery and a simple assault, domestic violence assault. Let me just look at this. I mean, let me just, first of all, I am going to appoint the public defender's office to represent you on this.
Yes, sir.
This gentleman apparently has some emotional problems. Read the affidavit, Bill.
I did, yes, sir.
And apparently they live in the same household. This was his sister, apparently.
Made threats, gestures, and then followed through with them is my reading of it. That he threatened her, made gestures to back that up and then followed through.
Drive over the seat.
Yes, sir.
Um,
Those are the allegations.
I know. I just. I don't know. Get out of contact. Mr. Tillman.
Yes, sir.
Because of the nature of what's going on here, the kind of the relationship that you've had, I am going to, there is probable cause. I'm setting the bail amount on the M1 at $1,000 and on the M2 it's $250. However, this is going to be as a condition of pretrial release.
Yes, sir.
You can't have any contact with your sister at this point. No contact means you can't call her, you can't talk to her, you can't be where she's at. Now, I know you two probably, or it appears that you might have lived in the same place. At some point, you're going to have to, once you're released, you can't go to the house other than to pick up personal effects with law enforcement present. This can be changed. Once a motion is filed with the court and we can get some further information from your parents and your sister.
Yes, sir. Completely understandable.
Okay, until that time, you can't have any contact with her.
I understand 110%.
Okay. So in any event, it's going to be as a result of that pretrial release with those standard conditions and also no possession of any gun, firearm, or other weapon.
Can you verify how much I owe per bond really quick? Because I couldn't hear it.
I'll repeat that. It's $1,000 on one of the counts and $250 on the other. So
thank you so much, Your Honor, and you have a marvelous evening.
Okay, thank you, sir. Do you have a copy of the Want a copy?
I've got a copy of that.
And you have that?
Definitely.
Okay, is that always concerning?
So you would want where you could go back at the time to get his stuff.
Yeah, you can go back one time to get all this stuff. Okay. Next case we'll call up is in regard to Bruce White.
So how you doing, Your Honor?
Thank you. Mr. White, you're here charged with battery by strangulation, battery or the simple battery, false imprisonment, and tampering with apparently witness in regard to the ongoing proceeding. We look through this. This is one I also had the question as to the false imprisonment aspect, because they were all voluntarily driving.
Sorry?
Okay. Said that entered the victims, drove back to the suspect's residence voluntarily.
As I'm reading, defendant grabbed the victim by the neck, dictating and preventing the victim from being able to breathe. While the victim attempted to exit the room, this incident occurred and grabbed the victim intentionally against her will, threw her onto the bed, preventing the victim from leaving the situation. By reading the wrong affidavit.
No, I just. Do you think that constitutes, because they didn't remove her anywhere, just kind of prohibited her from leaving?
That's why we didn't charge her with kidnapping.
That's exactly where my mind went. Mr. White, I find, looking, do you want to have a lawyer appointed, sir?
So I would like a lawyer appointed.
Pardon me? Would you like to have a lawyer appointed?
So if you don't mind, could I say something?
Every time he leans forward,
Yeah,
his
if you
muscles
lean
gonna be to
forward,
stay back.
it makes it tougher to hear. Just what are you saying? Would you like to have a lawyer appointed?
Yes, sir.
Don't
lean forward. Just answer the question. Don't lean forward. Okay. Don't lean into the microphone.
Yes, sir. I'm sorry.
You want a lawyer appointed?
Yes, sir.
Okay, I'll appoint a lawyer to represent you. In regard to the battery by strangulation, where there is probable cause here, I am setting the bail amount there at $5,000, on the battery touching at $1,000, on the false imprisonment $5,000, and the tampering, which is what aspect of this? What was that? Let's throw in the phone, grabbing the phone. Yes. Okay. And I'm going to, in light of the other amounts, I'm going to set the bail amount that at $10,000. All this is a condition of pretrial release with the first conditions of 8, 9, 10, 11, and 12. Standard ones will be in place. 16, not possessing, carrying any type of firearm, weapon, or ammunition. And 17, you're not to possess, or you're not to go anywhere close to having contact, go anywhere close to where this victim resides, place of work or vehicle. No contact means just that. No cards, no letters, no telephone calls, no attempts to contact with any third person. And that you didn't reside together, so I am appointing a lawyer to represent you with the bail amount set as I announced and those conditions, sir.
Your Honor, if you don't mind, could I say something?
Not about the case. What would you like to say?
I've never been in any type of trouble before.
Well, that's something that we'll take into consideration during the course of this. But those are the presumptive bail amounts for these types of crimes. Okay, next case I'll call up is in regard to Samuel Wilson.
Just stand up behind.
Yes. Mr. Wilson, you're here charged with tampering with an electronic monitoring device. Apparently, was he, what was the nature of that? He's apparently, were these as a part of pretrial release essentially? Okay. There's also, okay, there's two cases. One is for tampering with an electronic monitor device. The other is an underlying charge that apparently you are on some form of lease. It's indicated on that one on a no bond basis. Yes. By Catherine, Judge Company. So at this point, the new charge, the tampering with an electronic device charge is a third-degree felony. I am on probable cause, bail amount of $5,000. Do you wish to have a lawyer appointed there?
Yes.
Appoint the public defender's office. Apparently, you were on some form of pretrial release. Do you have a lawyer in that case?
Not anymore.
No. Okay.
You read what's on the screen?
Oh. Electronic monitoring. In any event, what I have is a capias, two separate capiases, and you're to be held on a no bond basis on case number CFT 5179. I'll appoint the public defender's office to represent you on everything so you can get this all squared away.
Okay, could you tell me my next court date, please?
The next court date, is any idea?
He has a 5-day hearing on Friday, the 22nd.
You'll have a 5-day hearing, so you'll be taken in front of the judge within 5 days, right?
All right, thank you.
This is what. Okay. And who's this gentleman? I don't know.
I'm Judge on Penson. Yes, ma'am.
Okay, this is an add-on for this afternoon. Okay, and this is Mr.
Penson.
Is it Jason Benson?
Judge on Penson, yes, sir.
Okay, Mr. Benson, you're alleged to have committed a domestic violence battery, and I can pull that. Okay, let me read through the probable cause affidavit. I did not see this earlier.
Yes, sir.
Okay, this says that there's nothing physical that happened.
A witness reported that there was something physical that happened. I believe that's the basis of the affidavit anyway, Judge.
She wasn't even around. Nothing physical happened, sir.
But I don't see witness, okay. Good contact with the alleged victim.
So she wants contact.
She doesn't want contact.
It says she does.
We have contacted the alleged victim is.
The victim's requesting contact and has made that clear to pretrial. Then the state would not object to a peaceable victim contact condition of pretrial release.
Okay. Yeah, just to make sure that something not occurring here. We'll go back to the judge.
Yes, sir. Nothing. Were you talking to me, sir? Or you was talking to the state?
What I'm going to do.
Was he talking to me? Oh, yes, ma'am. Were
I'm
you talking to
going
me, sir, or the state?
Hmm?
Okay.
Well,
Yes, sir.
first of all, would you like to have a lawyer appointed?
Yes, sir.
Yeah, I'll appoint a lawyer. In light of what's going on here, and this will be something you can, it appears that the victim is not saying anything happened. There's a witness that indicates something did happen.
Yeah, that witness is my mother. I'm sorry.
Let me just explain. What my goal is in all of this is to make sure nothing more happens or allegedly happens. What
Yes,
I'm
sir.
going to do in light of the conflicting information here, I am going to release you on your own recognizance with some pretrial conditions. Pretrial conditions is you're to have no violent contact with this alleged victim. That means if you two get in an argument, you need to back away. Don't get into an argument with her. You understand what I'm saying?
Yes, sir.
If nothing's going on, then you don't have anything to worry about. State's gonna further investigate this and see if they want to proceed with it. I'm releasing you on your own recognizance again with the condition that you have no violent contact. Don't let any arguments, so you don't assault her, don't threaten her, bottom line, just don't argue with her. Just get away from anything if she were to start something, because the burden's on you to avoid any allegations of improper contact with her, okay?
Okay, go ahead, state. My bad.
Second.
I believe I understand the court's intention. If there's to be any supervision, it cannot be an own recognizance release. It would need to be a straight pretrial release.
Okay,
So there'd be no bond amount.
Okay, that's fine, thank you. I'm releasing you straight to pretrial release. There's no bail amount that's being set. You don't have to put up any bond, but it's pretrial release. You'll report to pretrial 1 day a week. And that you will also be prohibited from having any violent contact. You're not to also, while this, have any type of firearm, gun, ammunition in and about you.
Okay. Yes, sir. Can I ask a question?
Sure.
If you could you like dumb it down for me? I don't understand what none of that means, sir. So could you like dumb it down for me?
As far as no contact.
Yeah, so I can't talk to her at all?
Yes, you can. You can have no violent contact. That means that you cannot assault her, you can't threaten her, you can't lift your fist to her. You and she get into an argument, you go to the other room. Don't let her goad you into doing anything. But you in any way touch her against her will, which is a battery, then it's on you. You understand that?
Yes, sir.
I want the state to have an opportunity to further investigate this.
How do I the pretrial stuff? What is that?
You're going to report to pretrial services. They'll give you some information. Pretrial services means that you're going to be monitored to some extent by reporting in to let them know what's going on with you. They're going to interview you. They'll take some information. But the primary thing is don't get into any arguments with her and let anything escalate out of hand, okay?
Okay. Yes, sir.
Okay, you have a lawyer that's going to be able to answer any further questions you might have.
All right. Yes, sir. I appreciate it.
Okay, good luck to you, sir.
Yes, sir. So am I released or?
Yeah.
Come on, man.
They'll explain everything to you.
Get out. One to the front.
I'll have to put somebody. No.